এটা কি পড়ে গেল রে? আপনি লাস্টটা না লাস্টটা এই তো এখানে
taking my lord leave to file an urgent application, my lord, for listing tomorrow or day after, my lord. Headmistress of an approved headmistress, my lord, she was manhandled within the school premises, assaulted, abused, almost.
When
That
was
was
the order passed?
the order was passed day before yesterday.
So what is the urgency?
The urgency is, my lord, I am required to hand over charge by today, and the headmistress's room, which is now sealed by the police, will be reopened, my lord, on Saturday. But I was praying, my lord, I'm required, because I'm not in a position to even enter the school premises because of threat to my life. My lord, and initially I was transferred.
48 hours notice there is to and
But
the day after tomorrow. 40. Served notice. Yes.
And my lord, it will be listed, my lord.
Day after tomorrow.
day after tomorrow.
I'm grateful.
Yes, all the
All right, item number 1, and I am appearing for moral appellant. The last occasion, yes, that matter, Lordship knows, my lord.
issued.
We have 3 vacancy. One, Hooghly Women's College, Maharaja Sirishchat College, and Jogomaya Devi College. But 3 college vacancy are reserve category. Reserve category. My lord, if Lordship has given us some more time, so because of we have already notified for receiving the requisition of fresh vacancy. If Lordship gives me about 10 days time, so we can, my lord, because of the petitioners category is general category. So 3 vacancy are reserve category. So if Lordship will allow me 10 days, so we can sort out the vacancy which now we are, my lord, receiving. If there is a vacancy in respect of your category, then we shall about 15 days.
2 weeks for it.
Yes.
2 weeks.
Yes.
Weeks.
So we take action.
Uh, 2 weeks since. Has it to be mentioned?
We be heading it again.
My lord, I appear for the appellant, my lord.
Why it is to be mentioned?
It was taken up on the soil location. Lordship will find there was an order to that effect. The issue is already been settled and already dictated over, and I have already
Hotel employee, hostel.
hostel. I think a copy of the order is there. If Lordship do further request.
Let there be an order of court, my lord. In this matter, my lord, let there be an order of court also.
Order of court. Obviously.
Order of court. Next day you will get order of court. Is it identical?
My lord, identical, almost, my lord, identical.
No, almost will not do. We will record your contents. Have you checked up? You are satisfied?
My lord, let there be, my lord, an order of court, my lord. Court.
Actually, these are the orders for appeals against Justice Sengupta's order. This one went missing from the bunch.
Oh.
There were 5 appeals, 4 were decided, and this was served a bit later. And that's the reason why it went missing from the bunch.
I filed it, my lord, separately, my lord.
He filed it
My lord, In this matter, Mr. Swapun Datto, my lord, leads me. My lord, other matter, Mr. Sen, my lord, lead.
So, issue is same.
No, you do one thing. You give us a corrected copy where we will pass the same order with alteration of the dates. Facts are identical.
Same. Issue is same.
So if issue is same, why didn't you, whatever we have.
Now, on that material point of time, 4 matters appeared. This went missing from the list.
Right, so you want the same order to
Same
be
order.
passed. So this order, you make the necessary indications where it is to be, corrected. This was
Only the order, impugned order date or the writ petition numbers. These are two which I'm making the whatever necessary, I'm handing over. Hmm?
advanced will be similar to the arguments which will be advanced here. তা ঠিক আছে, এটা
It's just a whole change for the cost title change হবে, রিট পিটিশন নাম্বার চেঞ্জ হবে, এগুলো আমি এসআই চেঞ্জ করে
November 2014 note sheet is also
Same,
there.
same.
Hmm?
This is the memo being adopted. Same department. Except for the writ petition number being under challenge, other things are in the same benchmark.
আসো, এইটা cost title এটা করবে।
দাদা, এইটা
এই জায়গা থেকে এই জায়গাটা এখানে শুধু ওই সব
It is the diploma holders matter, my lord, where your lordship desired that they should open a portal that came from your lordship to allow that diploma holders to appear in the TET examination. As your lordship allowed some diploma holders.
Dr. Vats?
My lord, I had a discussion. The portal which was originally opened for the specified time, there was no filter preventing these candidates from applying. So they could have applied and then raised their grievances, but they have not availed it. Secondly, what has your lordships had asked me on the last occasion that in the upper primary rules you have allowed diploma holders, but in the rules for recruiting the special educators, they have not been allowed. That instruction I have taken, though on the last day I had made certain submissions. That is the instruction which has also come, that these special educators will teach up to classes 12. There will not be 10 special educators in one school. Rather, there might be one special educator looking after 2 schools. So, the special educator recruitment is from classes 5 to 12. So, a diploma holder cannot teach in 9, 10, 11, 12. But a degree holder who teaches in 9, 10, 11, 12, he can also teach in the. That is why they are not included in the 2024 rules for recruiting special educators.
We are not on recruitment. We are TET. We are on TET. As you indicated, we incorporated that clause that this order is pertaining to appearance in TET without any. This will not create any right in their favor to participate in this election. Is agreeable.
Yes, but then in that case, at such a belated stage, so many candidates, 49 candidates are before the court.
So you issue a notification giving a particular frame of time. There is
That
no-
will open the entire thing.
in respect of the persons who are pursuing the he is a
Diploma holder in special
diploma
education.
pertaining to diploma holder, restricting it to TET, that you yourself can incorporate in the notification.
Or else, subject to what your lordships. Then, like in the previous matters, allow them to come and apply, and we will take their offline applications and we will put it into the portal. Like in
As your lordship. As your lordship.
instead of giving a notification and opening further applicants, those who are before the court, at least let
Where
it.
is that order?
So if another application is filed tomorrow, okay?
No, this is more or less contemporaneously filed within 2 days of closing the portal. But those who will come now, at least I hope your lordships will not allow them. Make one observation that this is restricted to these candidates because they had approached. In the other matter also there was a restriction. Your lordships had restricted it to the candidates only.
Dr. Patra, we can pass the same order.
Lordship.
present appeal has referred. Please.
4, 5 and 6, my lord, judgment delivered by Honorable Justice Chatterjee, my lord.
Order has been complied with, my lord. Why they preferred the appeal, I don't know.
I do it.
60% person have already paid. That B.Ed college man. Engineering college. Engineering. BCI engineering.
My lord, only thing, my lord, let it be placed before the
All the three matters.
the 3 matters.
No, we have passed one matter, two matters we will be taking up.
Gratefully, Your Lordship.
That I appear for the appellant request. My lord, I just made right, what? Well, I made a for the basic dates so that lordships are not required to go to any of the papers.
Where is the commission?
I appear on behalf of the Commission, Your Lordship. I'm led by Mr. Kolai Mandavati, and it's senior.
Where is he? Where is Mr. Montworth?
Mr. Bandapati is in courtroom number 18, Lordships. He's in before courtroom number 18 on his legs.
He's coming now.
He's coming.
Let him start. Yes.
Lordship, kindly take the list of.
Just remind us what.
Yes, that's the reason I thought that I would not take your lordships to any of these papers. So this 3 pages would be enough for this matter. Kindly take this list of dates. No, this is given.
Hey, thou article is.
Two copies. Well, may I just say the basic facts because my lord, 30th May was the advertisement for the recruitment. Now, commission on 16th of June, they elaborated how this has to be done. And lordship may kindly see serial number 2. The portal was designed in such a fashion that selecting SC makes only rupees 200. So anybody selecting general, he will not be able to get 200. Thereafter, my lord, on 24th of June 2025, my lord, they referred the SLP number which was exclusively relating to OBC matter before the Honorable Supreme Court. Now, serial number 4. My lord, this is
What is C?
yes, I am SC, that is admitted. There is no doubt about that. Now, before placing it, may I just say what is the one single point which is troubling maybe them or which is the real bone of contention? Lordships, kindly take serial number 13.
Yes, 30.
Kindly take serial number 30.
When you started? বলার কথা আমি বলি
Serial
মানে
number.
why he has started, he has finished.
No, no, not.
All
Last day.
I
he
just
has
That's
given a
it.
list of
His
the
junior has said that yesterday Mr.
No.
Dhar has completed.
When I finished, there was no opposition by you.
Yesterday we did not hear because you were not there.
That's different thing, but
Passed
why he
it
has
over.
No, your opposition was not there.
Passed it over just.
that's correct.
We wanted just to recapitulate.
Very nice.
capitulate the
Then it
fact.
will continue, I think. Hope for 2 hours.
No, no.
No, you tell me now, then I can finish the other course. I have other matters also. How many things? 2 hours?
I take
You
the
don't
joke
want
in a
to
right
decode
spirit.
us, Mr.
No,
Bandhu.
yes.
It
huh?
will
Don't
take
want
not
to
even 10
decode us.
I am coming then.
If
Take at least half an hour, please.
No, no.
For my requesting
No,
you.
no, my,
Please take.
please be here.
Mr. Bandhu, what happened? We requested you.
Bro, very difficult. Very difficult. Okay, I'm coming. You continue.
You
No,
tell
no,
us when you are coming.
this is a short matter.
This is a long matter. You have argued for 2 hours. It's a short matter. A council like Mr. Dhar, he is arguing a matter for 2 hours. Can it be a short matter?
What is the definition of 2 hours?
2 hours means
No,
60, or 120 minutes.
Fees should be reduced.
yes.
Eh?
His fees should be reduced.
This is the pro bono matter.
What pro bono?
Pro bono means I don't get a fee.
You
Achha,
don't
Mr.
get fee, your
Bandhu,
junior, others get
Other
fees.
matters,
Mr. Bandhu, tell us when can you come?
I am coming, just come, 5 or 10 minutes.
Very good.
He let him continue. I am coming, my lord. I will do this.
You
Hey,
take.
In the meantime, he will start, if required.
Yes.
ঘাবড়াবার কিছু নেই করো আমাকেও তো হার দাও জলসেমের সামনে একটু মামলাটা করো তো অন্তত and the problem is these people I tell you my lord whole day he was with me yesterday.
May I just say what is the crux of the
Yeah,
matter?
but you have taken us to serial 13.
Yes,
Sure.
13.
We have heard you. We wanted just to know
Right,
what was.
serial 13 is that was the division bench order
Uh,
which,
are at liberty to deal with such who are not governed by this order in accordance with law.
right, and on the basis of serial number 13, what they did, page 33 of the supplementary affidavit. Kindly take 30.
So they opened.
No, not only they did so, kindly take 33, my lord, it will be clear, of the supplementary affidavit. They acknowledged that they did a mess up. Sorry,
Page 33.
3 of the supplementary affidavit.
Yes.
Kindly take third paragraph.
33.
Yes.
Yes.
Kindly take third paragraph. First 2 paragraphs are following the division bench order. They are opening the portal. I also, my lord, applied in the portal, and I was also treated as an SC because I am an SC. But my only difficulty and shortcoming was I did not file a writ petition. Kindly look at third paragraph. Similarly, following the spirit of the order dated such and such, all candidates of 9 and 10 who fill their application forms by paying an application fee of 200, just like me, are also given a final opportunity to edit their categories to SC.
Page 30. Supplementary.
Not the stay application, supplementary. Third paragraph.
Yes, we have seen it.
Yes, my lord, my reason of showing third paragraph is this. First 2 paragraph was in compliance of the Honorable Division Bench order, which was restricted to 11-12. For class 9 and 10, there was no directions of the Honorable Division Bench, but they realized genuinely they made a mistake, number 1, and they cannot change. And
Then what happened? Tell us now.
they allowed everyone to change it for class 9 and 10.
So you also changed.
No, I am for class 11,
You are for
11,
9
12.
and 10.
No, I am for statistics. It's 11 and 12.
So that's that division bench order was in respect of what?
Restricted to only 11 and 12.
Yes. So you are also 11 and 12.
Yeah, exactly. And the division bench order was this, that whoever has filed these writ petitions by 2:30, by 16th of December, 16th of December, whoever has filed, now,
Filed when?
my lord, I rushed from Jalpaiguri, I filed on 18th. And on the portal also, like everyone else, I
So the third paragraph you gave, the commission gave liberty to you to edit up to 17th of December.
that paragraph, the reason of showing is that first two paragraphs, they are bound to do. That's the division bench order. Third paragraph, there was no requirement on the part of the commission to allow everyone else who did not file the writ petition. So my point is, today if they take a stand, no, we cannot help you because you did not file a writ petition, then why did you help everyone under third paragraph? There was no writ petition, there was no
That
division.
was 9 and 10.
Exactly that. So point is, somebody within time was 21st of July 2025, who made an application and SC.
Where is this order of division bench order of 1612?
Yes, this order, this is, kindly take this page 53
Of
the stay application. Relevant portion is 58.
it was in respect of 11 and 12.
Yes, because it arose from the single bench order, and where, would your lordships first have a look at what the directions of the honorable single bench, precisely one paragraph,
The operating portion of
that
the
is paragraph 20, page
Huh?
58.
Single bench order.
Let's 58, paragraph 20.
Yes.
Well, may I place it? We clarify that this measure is limited to persons who approach this court on this issue till 2:30 p.m. today by way of filing of the writ petition or appeal or otherwise. Full stop. Authorities, now this is the area. Authorities are at liberty to deal with such of the candidates who are not governed by this order in accordance with law. Meaning thereby, relief directly granted to file the writ petition, liberty to the authorities in accordance with law, whatever they think. So on that basis, they open the portal. I also applied, though I didn't file a writ petition, I also applied.
Pursuant to 17th of December order.
Yes, yes.
You applied.
Yes, I applied in the portal.
Where is that application?
That lordship will see.
Applied for editing.
Yes.
So you admitted you applied as general.
No. I never applied as a general. This editing option was exclusively available to those who paid 200, not for general. It's an acknowledgement that they did a mistake. My lord, kindly consider that commission would never open the portal unless they understand and realize they made a mistake. They converted SC candidates to general because of their own mistake by referring to OBC matter of pending in SLP.
Now, if they open portal
Yes.
beyond the time fixed by the division bench
Yes.
or the candidate for class 11 and 12,
Correct.
that would be contrary to the division bench judgment.
It will never be a contrary to the division bench judgment because of the Honorable Supreme Court clearly saying that what is the accordance with law. Well, I have 2 points.
What is?
Because the division bench have said 2 things. One, open the portal for all those candidates, whoever filed the writ petition. There is other part, For others,
in accordance with
accordance with law.
yes.
Now, my point, I am not seeking any like mercy. Why I say this? I belong to SC. I applied as SC.
Yes, you have given 200 rupees fees.
Now this
They
is
are accepted
now
the
last date was
but following a dispute cropped up regarding the OBC candidate, they asked all the candidates
yes,
apply for the post to edit their category.
yes.
It's for 9.
But then I thought I am not an
Edit
OBC.
their
Why did I?
category before that date to all candidates. But you have not done it.
But that was
Lastly, division bench says that in respect of page 70, we are concerned in this appeal with regard to the candidate participating in the selection process 11 and 12 only.
correct.
In such circumstances,
Yes.
then the division bench fixed a date
Paragraph 20 about.
that you keep the portal open for the candidate for 11 and 12
Yes.
uh,
Yes.
classes up to that.
But
And the rest for whom this judgment is not applicable,
I don't say anything.
deal with in accordance with.
Absolutely right. Now, if the law says that I am not entitled to, I am not entitled to. If the law says this, that I am entitled to, then I am entitled to.
What
Not,
happened?
not that. If this portion of the division bench order stands,
Yes.
whether it
Madam,
will
may I
be
say this?
proper.
Kindly visualize, it would be so drastic. Division bench order is that everyone would be able to edit. Now, who are the everyone who made an application under 200, just like me? So, what is the difference between everyone and me? Everyone filed a writ petitions. I didn't file a writ petition.
Also very good. Then what you did after
Yes.
this? What you did?
Kindly see, after that on 17, that is the very next date. See,
17
serial number 15. Kindly take serial number 15.
page number.
No, I'm saying, madam, this list of dates. List of
List of dates.
So, like everyone, on the very next date,
You
kindly
are
see.
for 11. You are for 11 and 12.
Yes, statistics is 11 and 12.
So this opening of portal pertaining to third paragraph is restricted to 9 and 10.
Exactly. And
Now,
for
now
me,
what you did? You did what?
I did serial number 15C.
Serial number 15
C.
updated carried through portal.
Yes, page 73. They called me also in the verification.
No, that
My fault is,
but you are saying third paragraph is for 9 and 10. You do not fall within that category.
correct,
Your is 11 and 12.
correct.
They have said 11 and 12 be opened in terms of appeal court order for this period, no further extension, and it is restricted to the persons who approach the court prior to that.
Division bench order, up to division bench order.
Then why did you go for this fresh edit option when you are not pertaining to this 9 and 10?
Well, I had two options. One, ignore everything, sit tight and think as if I have done correctly. One option.
Yes.
Because I did everything right. On my part, there was no mistake. Other option is, after acknowledging mistake for everyone who filed the writ petition, portal is open. It's a mechanism. So they may face trouble if I come later on. So I also edit myself because I belong to SC.
That editing option was open to you, open to class 9 and 10 applicants.
No,
not to you.
editing option was it's
After the
open
division.
for everyone, but I have to give a WP number.
Initially, it was open to all. All are
Yes.
instructed to edit the option. All.
Yes.
Where is that notification?
Kindly come to serial number.
Till the page number where on that date,
First, Lordship, kindly take serial number 6. That was the last date of application. 20, serial number 6. Well, this is page And the page is at,
When did you first apply? Where is that?
yes, serial number 4, 2nd of July,
Page number
Page
Well,
number,
page
you said
number is-
that.
page 37
of
of supplementary affidavit,
page 37.
37. Within time.
Now, very good.
So my point is, after the last date, kindly have a look at the last date.
What is the
Last date was
Yes,
page 39 of the stay application.
that is
Is it?
21st July.
Yes, it is mentioned 14, but it was extended to 21st. I take it 21st.
Page 30.
Page 39.
Yes. This notification was issued
30 is
of
the May.
recruitment notification.
Yes, this is the recruitment notification. It
Page
begins at 30.
35, APD in opposition.
Yes. Now 35 is that 200 and 500 thing.
No,
Lordship is saying
having regard to such and such,
35.
35 of affidavit in opposition.
of Lordship is saying opposition.
Yes.
That is also there.
Well, that is there already in my supplementary
In
affidavit.
para 2, those who may have already submitted category details,
Yes. Well,
it is indicated to you also. You may be required to resubmit the category details prior to such date.
but that,
Resubmit their
may I say this? All those were with reference to the OBC matters which was pending.
Where is your opposition? You filed it. Opposition you filed.
Yes, yes, yes. Well, they filed opposition. We also filed a reply to that.
Last day we had given the opposition.
Opposition page for 35.
35, হ্যাঁ, resubmit করতে বলেছে।
Extra work. Supplementary.
তা তো OBC নয়।
হ্যাঁ, এই যেটা বলছে category details not being collected.
Well, this refers to Amol Chandra matters. I have shown that. Nobody gives a concession of opening portal unless they realize their mistake.
এই মামলার জন্য আমরা category details collect করিনি।
হ্যাঁ। See,
Well, there are variety, more than 25 new categories have come up. And some OBC.
ও আচ্ছা আচ্ছা, naming the
Exactly. Now, my
Now,
point,
very good. You tell us what did you do? You resubmit.
last date was 21st of July.
You are not on that.
Yes,
21st of July was the last date.
last date.
That was extended till, for this correction, it was
No,
extended.
the 21st remained the last date. It was never extended. 21st was the last date.
Where is the date? Where is the?
Well, page 39 of the stay application. Well, that's the reason I thought Lordship need not see the pages. Kindly take the list of dates. Otherwise,
39. So this was filed after, within the extended period.
this, sorry,
For the OBC, the portal was opened, saying that you edit giving the OBC particular category. You are not coming within the zone of that judgment.
absolutely right.
So you did, after marking as SC,
Yes.
as per the extended date in page 40, as per that page
Page
35.
39.
This 35 notification in terms of order was issued when?
This
Of the
35,
extended?
it was issued on
24th of June 2025.
yes,
And the last date was 21st of July 2020.
yes.
So you did not respond to this because according to you, this is not covering. This is your argument. Yes. Now, after this editing circular was given at page 29, when did you opt for editing again?
I never opted for editing.
For 24/6/2020.
I have never opted for it. I have only opted for it after the division bench, when everyone got it, opted for it. I never opted for it because my understanding was this.
So after the division bench order, the portal was reopened during the period from
It was for one day from 16th to 17th December. 16th was the order of the division bench.
17th was open.
Yes. And when this was opened, yes, it was opened on 16th itself. 16th, 8:30 p.m. it was opened and remain opened up to 17th.
So you went and again edited.
Exactly. Now
Now what happened? Suppose after this editing, what problem you faced?
I was called an SC.
Were called
Yes.
for verification.
Yes.
Now how you come to learn that your case has been rejected?
Because
The memo impugned before the writ court.
no, I was called as an SC. Thereafter, they rejected me.
Where is that?
Well,
Rejected you?
Page 70. Just a second. 70.
11, 12 এর ক্ষেত্রে রিপিটিশনের নাম্বারটা বলতে হবে। 170
Kindly take for page 74. Rejection.
must show.
Page 74
Page 74
of the
of the stay application.
PS 74. What you are showing?
Serial number 128. That like others also, I was treated an SC. Because I am an SC and I also updated portal. Serial number 128. Page 41.
Now how did they reject?
Now there is no reasoned order of rejections. Now I am number 1 in the zone because I have got 47.
How did you come to learn that your case is not
Now they
you
have.
were called for verification when?
I was called for verification at page number. Just a second. 30 December 2025. On 30th December.
30th
December. Page 73. Then they said that you would be treated as a general, not an SC. Because, but there is no reasoned order for that. There is no reasoned order for that.
Ajay, you answered our query.
Yes.
Judgment of Supreme Court was pertaining to OBC.
Yes.
And judgment of our division bench was pertaining to SC ST.
Correct.
SC ST. So by virtue of that division bench judgment, you are not being granted the opportunity because you did not apply within that period.
No,
You
not
did
apply.
file the writ petition within the
Yes. Yes.
and the remaining option for other candidates was left to be considered in accordance with law. This was your
Absolutely.
so the Supreme Court judgment HON'BLE Chandra Das is pertaining to OBC which has no relevance with you. Then why did you edit again in terms of the opening of portal pertaining to OBC candidates?
Because of this reason, once I came to know that the division bench.
You were confused.
No, not confused, my lord. Not confused.
So you went and
Now, what is
edited. You went and edited for the first paragraph direction or for the third paragraph direction? Are you allowed to
No, not
edit?
third paragraph. Not third paragraph. I am trying to say that school service commissions cannot say it's an watertight order. If it is in watertight, then why do you allow it? Why do you open the portal for 9 and 10? There is no direction.
Mandatory bring the
I
proof
say
that they file appropriate writ petition by 2:30 p.m. on as mentioned in the aforesaid notice.
So everything is closed on 21st of July.
ওই অর্ডারটার পর
If they are right, then they are right.
এবং এই নোটিশটা দিয়েছে
কোন অর্ডারটার পর?
ডিভিশন বেঞ্চের অর্ডারটা
হ্যাঁ।
ওদের একেও দেখেছিল, সবাইকেই দেখেছিল এবং
There are
11, 12 যারা এই যে তারপরে আছে
Opposition.
এটা একটা নোটিশ না, স্টে অ্যাপ্লিকেশনই আছে। স্টে অ্যাপ্লিকেশনে আছে
Paragraph.
আপনার এই অর্ডারটার পরে, ডিভিশন বেঞ্চের অর্ডারের পরে, ডিভিশন করেনি 71, 73 দিন, 73।
Division bench order টা কবে?
order,
শুক্রবার।
It was only for
সিঙ্গেল
SCL.
বেঞ্চের অর্ডারটা করে। সিঙ্গেল বেঞ্চের অর্ডারটা করে, অর্ডার এন্ট্রি অর্ডার করে।
শুক্রবারও is the order in appeal.
এইবার এইটা এরা এত ইয়ে করে ফেলেছে না, কম্পাইলেশন আনলে বার করা যাচ্ছে না। এই দেশ
ওরা ওইটাতে আসে না application করে।
এইবার ওদের বললো যে এইখানেও আছে যে তোমাকে দেখাতে হবে, তুমি এসো, তোমার আমরা সব ঠিক করবো, দেখাতে হবে তুমি 16/12/2025
এসে আসুন।
আগে তুমি রিপিটিশন ফাইল করেছো।
That division bench order has not been assailed by anybody.
No. So my lacking,
notification.
is this. If I,
Where
if
is
I
the-
can go,
Have you annexed the first notification?
I have annexed all the notifications. Kindly take my
First
supplement.
notification whereby application was invited or invited.
First notification 30th of May. That is
Yes,
annexed.
yes.
And under that, they can't do anything after 21st
No,
of July.
now category what instruction was given
Yes.
to the candidate regarding their category.
Kindly take my supplementary affidavit, page number 25. Sorry, page number 30
Application for stay also.
is there.
Application for stay. Application for stay, you take us. What was the instruction given
Kindly
regarding the
take my
category?
lordship's answer is page 13 of supplementary affidavit. Kindly take page 13. That how, on the basis of the advertisement, how I apply. Kindly see 3 pages from that notification. First page is page number 12, serial number 9, category, candidate's own category. Well, first is, next page is page number next page.
So
30.
initially in the notification, candidates were instructed to mention their own category. Initially. According to you mention SC and paid the fees meant for SC candidate for your category.
And that's
Subsequently, following a dispute or case cropped up regarding OBC candidate,
Right.
which went up to the Supreme Court, they asked the candidate to resubmit.
yes, which I did not.
You didn't,
Correct.
because of the fact you say your ground is that there was no requirement,
Yes.
because I have correctly mentioned, and Supreme Court decision is not applicable
Yes.
to you. But subsequently you found that you are called in verification, and in
No,
verification
there is a story.
you have been shown as general.
No, subsequently a writ petition was filed. The Honorable Single Judge held they cannot convert any SC to general. So there is a clear finding, and that was not set aside. That was challenged before the Honorable Division Bench. The Division Bench asked Mr. Bandyopadhyay, should I decide on merit? Take instruction. Then Mr. Bandyopadhyay said, yes, my lord, there is no requirement. We are opening the portal. Then Division Bench said, very good. Then we are extending it, open it for 24 hours.
What
Whoever
is
has
page 40 then? Page 40 of your supplementary?
page 40.
Here the category, this is what?
General দেখিয়ে দিয়েছে।
Page 40 of your supplement.
Right.
What is this?
Yes. Page 40 has to be seen with page 37. Kindly keep both side by side.
Page 37, yes.
Page 37, kindly see the date. Date is at page 38. 2nd July, within time, within 21st July. So that's SC, it's showing application SC, ST, PH 200. So
What is page 40 then?
now page 40 is their software conversion. When they kindly look at date at page 41, 17 December, that is just one day after. When I download it from this, I see now they have converted me to general.
Then you went for editing.
Then because portal was there, I got to know, I didn't see the judgment. I saw that it has to be edited. I also edited. So, but so
On the same date.
on the same day. So there is no delay on my part.
Thereafter, you were called.
Thereafter, I took 24 hours. I also filed the writ petition.
That is after for 17 December,
Yes.
you filed a writ petition.
Yes. On the very next date, 18th.
18th writ petition was filed.
Yes.
Because that was constant power saver.
And your case was rejected since you are not covering with
Case was rejected. I think, my lord, if they couldn't explain it purely after seeing page 40. Because the learned single bench found,
Where is the order impugned?
single bench found that as if from the day one, I submitted as general. Because page 40 is showing show.
Which page?
Can you see page 40?
Page, your order
Oh.
of the single judge.
Oh, order of the single.
That is at page.
Yes, that is at 68 of this day application. In fact, no one knew
Yeah,
about it.
At least his lawyers knew. He could have said to,
He-
at least that client's lawyers knew. No one knew.
Oh.
Everybody knows. তুই একটা করে কেস করে না সঙ্গে সঙ্গে পোস্টিং করে অ্যাডভার্টাইজমেন্ট করে তারপর চলে যাবে
Sometimes silence is the best answer.
Yes, you try to build up the habit of and speak less. Yes. Not take much. ये लागू কাউকে করতে হবে। এটা 11th কিছুই হয় না আমাদের
সেটা রেস্ট্রিক্ট করলো কেন? করেনি ও বলে যে other candidates will in accordance with
11, 12 তো করে দেবে 16 তারিখের মধ্যে 17 তারিখ
You will get reply.
No,
Let us hear
the
from.
judgment, there is a direct judgment. What is that in accordance with law? Now,
আরে আমারটা শুনুক তারপর তো জাজমেন্ট আছে ইন অ্যাকর্ডেন্স উইথ ল শুধু
paragraph 14
হোয়াট
of 2024 SCC online SC 3664. I will show only two judgments.
এখনো তুই
How we shall come out from the rigor of the division bench judgment.
On the basis of paragraph 14 of this
In
judgment.
respect-
জজ
in
সাহেবরা এত
accordance with law, it
Yes.
will be applicable in respect of candidate of 9 and 10. But 11, 12, a division bench taking note of all things
No.
that the commission has done, although OBC candidate, but commission has done in respect of all students,
Yes.
all candidates.
Yes.
A division bench has stated that
Yes.
in respect of 11 and 12,
Yes.
I am fixing a date. Who have filed a writ petition, they will be allowed to
It's a
resubmit
positive
their.
thing. It's not a negative then. Can I kindly see what will be law
How we are being the bench of
coming
real
to
strength,
court
how
and
we
knocking
will
the door?
come out. You help us. Yes, we are with
Yes.
you.
Paragraph 14.
How we shall come out
I
from
get
that rigor.
I have got it. Paragraph 14. Can you take this? Paragraph 14. It is a well settled principle of law where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his or her favor, others similarly situated ought to be extended the benefit
Yes.
without. In my case, even I
But
filed that
provided they are not fence sitter.
no question of, well, in fact,
Ultimate decision of the Supreme Court is that provided they are not the fence sitter.
these are old
well,
laws
if
Similar benefit is to be
no, my
extended
lord,
to.
this is, if
similarly
lordship holds this
situated
is
candidate.
fence sitter, then the definition of fence sitter has to be different. Kindly wish,
Regarding this proposition of law,
may I say,
whether you are fence sitter
Madam,
or
may I
not,
say
we
this,
have not concluded as yet,
may
and we have not stated as yet.
may I respond?
Position of law ultimately reached to this position.
My two things are different. One, do not give it to others. That is not there in the division bench judgment. Two, I am giving to them. Others, you decide in accordance with law. These two things are completely different. Kindly do not interpret that we are giving the relief to them. It doesn't mean that division bench are saying that this relief would be restricted to them and them only. No. Otherwise, that liberty would not have been given, which has to be exercised in accordance with law. This cannot be applied to someone who
Okay,
did not apply under
Let,
command.
let us read the paragraph again.
Paragraph 20, yes.
No, we are coming. Paragraph from paragraph 17 to 19.
But ultimately, it is the 20. May I read it? We clarify that this measure
ভাই আরে
limited to persons who approach this court on this issue till 2:30 p.m. today by way of filing the writ petition or appeal or otherwise. Right?
Right.
But there, it is not ending of it. Thereafter, authorities at liberty to deal with such of the candidates who are not governed by this order in accordance with law. Well,
Yes.
this is
Now you categorize yourself. Whether you are governed with this year last the two lines of the paragraph 20, or you will be governed by the other paragraph, the preceding paragraph.
well, in a recruitment process. Sorry.
Can I request one to your lordship? But he will not finish. Give me
No
10 or
problem.
15,
Just one more
10 or
judgment is
15
there, I
minutes.
finish.
I have other matters also. He will not finish. Last day 2 hours. Today,
Yes.
Well,
yes.
he's not. Well, the
No, no, no.
judgment by Supreme
You will show it later on. No, no.
What we have heard you. Let
Then-
him hear. Yes.
Your lordships have read the or judgment impugned in this petition. But this is an appeal court, whether your lordships will discretion exercise or not. The fact is this, Lord. Kindly see the documents first. I will not even rely this. ওইটা কই তোমার দেখা
আমাদের অপোজিশন আছে
তোকে আমার অপোজিশন তোকে মেন পিটিশনের ডকুমেন্ট গুলো দেখ মাথা একবার ঢুকলে একবার
Edit notice implementation and supplementary affidavit আছে।
কোথায়?
Supplementary.
Now, my lord, kindly see their supplementary evidence. Page 29. Supplementary list filed by them. Supplementary petition.
Yes.
First is 24 June 2025. Having regard to orders which may be passed in the special petition number so in the Honorable Supreme Court of India arising out of judgment and order dated so and connected retribution for the time category details are not being collected and will be collected in due course prior to the application being processed. Then we have said so. Now you can't raise a question. That was a OBC matter. Why the SC? You could have raised the question that point of time. Why category details have not been?
How he will know, Mr. Bandhavati?
This is a notification.
Notification in terms of HON'BLE's judgment.
No. This is a notification.
Having regard to the order passed by the division
Oh,
bench.
well, I'm sorry, Millard. This is we have put it in the website in these matters.
In these matters means of,
SSC website.
yes,
If prior to this, the commencement has been made,
right.
right? Category details were not sought for. Earlier, on the other day, I was showing to a lot.
For OBC.
Not for ABC, not for anybody.
How in SC there can be a categorical?
No, we have not sought for only SC, ST, OBC fees.
Where do we find that SC, ST, OBC all have to give these category details?
I am coming, just give me. First, we said that no category details we are not required. Maybe emulsion matters, etc. We don't want. We are also waiting. Now, Miller, kindly come next. Page is 30th July 2025. Huh? Next page. This is to notify that 30th July 2025. This is to notify that all concerned to taken SSC for classes so and so, this so and so, and connected matters. The online portal will be open for the collection of category details from 5th August 2025 to 11th August 2025. We have said so. This there he has annexed it. The category details will be collected from 5th August to 11th August 2025. Then Miller kindly come 5th August 2005. In continuation to an earlier notice issued with a memo number dated 30th, this is to further notify for information that all candidates, irrespective of their categories, are required to mention the specific category, caste, class, EWs, PH, etc. in the respective place in their application through the edit option provided in the website from 5th August 2025 to 12th August 2005. It covers everyone.
Yes.
It covers everyone. He didn't exercise his option within that time.
One question, Mr. Bandhavati. Is there any category detail of SC, ST like in OBC we have?
Schedule caste is a category, na?
Yes, that's
Schedule type is a category.
has no further recognition that it belongs to these groups. That is why he is SC. OBC, it is totally different subject to be considered.
But we have made it.
We
Let's assume.
understand.
Let me say. If anyone has objection at that point of time, why didn't come?
Yes, that he did not come.
Why you didn't come? No point to raise all these things today. You have accepted everything. Now, my lord, kindly come. 22nd September 2025. And everyone has understood. Everyone has given a simple. One gentleman has not understood. 32. 22nd September. This is to notify all concerned that though opportunity for uploading caste category have been offered to the candidates several times, the number of candidates have not yet updated the categories in their application. Therefore, a last opportunity is being given to the candidates to update the application SLST 1911. The candidates will have to first log in the edit option, then on the category from the down to the category will also have to specify in case the candidate failed to establish answer. Therefore, again we have extended time up to 26 September 2025. He was sleeping. He didn't exercise his option. Now I am coming to the main question, and I will clarify that. What is his case? I have given 200, therefore I should be given allotted to it. This is the point I was contesting before the other division bench. Kindly come. ওটা খোলতো অ্যাপ্লিকেশনটা রেট কোন অ্যাপ্লিকেশন শুল্ক সিলটা kindly come. Page 37, supplementary list.
37 of supplementary.
37 supplementary, my lord. 37 supplementary list.
Yes.
Application fees. Data copy. This is this.
37 of supplementary.
Supplementary list.
Supplementary affidavit.
Yes, sorry, list. I am very sorry. Actually, since yesterday, this list is going. Application fees. Schedule caste, stroke schedule type, stroke PH. Everyone. Therefore, application fees have been given. That did not say that you are schedule caste or schedule type or PH. Because I know categorize, I will make this application, they will take.
Mr. Bandyopadhyay, we are asking,
My
you
lord.
are right, that he has slept over the matter. We are wanting to know in SC, ST, PH, can there be any further categorization? Just
No, ST, no category.
Right.
The question,
so,
my lord, kindly appreciate it. Since your lordships have dealt with the Amal Chandra's case, that is the reason your lordship is asking this question, categorization. OBC 1, OBC 2, etc. Otherwise, no court will ask this question. Because this is not acquainted with this. My lord, Justice Chakraborty has been very much acquainted with the OBC A, B category. Correct, my lord? It is a category. Ultimately, when you are looking into the OBC matter, OBC thing, why category, OBC A, OBC B, why, that's a different part. Now,
everybody understood except him.
category means even if it's a general category,
Yes.
general category, then you have to pay 500 rupees. If you are SC, ST, then you have to pay 200 fees. Suppose I am a general category, what I would have written? General category. But in his application, he has written SC, ST, OBC, PH, etc. Now, let's take it, forget about this. How can you identify his SC? Maybe SC. Maybe PH. Why should I keep him in the SC category? Only because of this entry itself. I am saying only on the basis of this, alone this OBC category itself. Therefore, he may be SC, he may be ST, he may be another PH, he may be. We have given the notification, please, you notify it. You give it. Time was extended up to 26th September. 26th September, he did not come. Kindly come to Milot. আরেকটা কি দেখাচ্ছিল ওটা আরেকটা কি দেখাচ্ছিল ওর কি আরেকটা কি দেখাচ্ছিল Now, since he has not given, I have to explain this one later on, because he, in accordance with law, I will show what is in accordance with law. Now, since he did not opt for within 26 September, his name is come as general. Category general. See,
ওরা একটা পানিশমেন্ট দিয়ে জেনারেল করছে।
page 14.
এক্ষেত্রে যে ক্যান্ডিডেটস ওন ক্যাটাগরিটা কেন সে নিচ্ছে না? ওন ক্যাটাগরি যেটা ছিল না ওইখানে লেখা আছে একটা নোটিফিকেশন ওন ক্যাটাগরি
for. Then we have issued this one this is at page 40. Page 40, we have to say about category general. Otherwise, he would not have considered at all. We wanted to give him life. On that, we could have cancelled. Now, kindly say this is general, category general. Now, this has been issued by us. This has not been written by him. He was aware about this.
Page 40.
Page 40.
Yes.
Yes, page 40.
He was.
He didn't come and challenge.
This was done on 17 December. He filed it on 18 December.
No, not 17th December. He has printed on 17th December. This, yes. It a copy of page.
He downloaded the copy on 17.
7?
After 7th November,
But after 7 November, it was given. 7th November. 7 November. 7 November, it was made available. He has printed on 19th December.
This was page 40 was available from month of
7th November. Ma'am, kindly come to page 44 of the stay petition.
Selection committee or commission, whatever may be, the authority entrusted with the job of selecting candidate, issued a notification, giving instruction to the candidate to do certain thing. That is not binding. If that said thing is done, that is not binding upon the candidate, binding upon the commission also.
Bind both.
Both. So you are instructing that you mention your own category.
Correct.
In your application.
Yes.
All candidates mention the same. Subsequently, you say, look, regarding OBC candidate on
where is his application? Just 1 minute there. Where his application, he said category scheduled caste.
Yes.
Category?
Scheduled caste.
Yes, mention SC.
Kindly see, na.
You come to supplementary page 12. What you have instructed.
Page 12. No, what I am instruction now, not what is he has done it.
Yes. You
Kindly see. Kindly see.
Candidate's own category. You instructed them.
This is our brochure, my lord.
Yes. Brochure may serve.
I understand. But this was the first day on your lordship's question.
Yes.
Brochure is an administrative instruction, nothing more than that. Is it a law? Is it a legislative authority? Your lordship from the very first day, brochure is an administrative order. Can I not change by it as administrative order? Brochure is not a Ramayana Mahabharata Gita.
Okay, what is advertisement? Inviting applicants.
Now, can your lordship ask this question to me even? What was in the advertisement? I'm sorry, my lord. Kindly give deep respect. With deep respect to your lordship.
Court cannot ask any.
No. There is a court can ask any question, but there is a stage of the court. Court must know what is the stage, whether I will ask the question or not. Today, can you hear everything from the mouths? Keeping everything in a volatile?
We have not reopened anything.
No, I am not. I am saying, no, you are not. I am saying the court is not concerned, and whenever a question is raised, what I am going to raise, what is the effect of that?
That you can raise.
That's what I am saying. Your lordship from the very first day, still it is your lordship in the brochure. Kindly do not mind. Take it as a senior person. Kindly try to progress. It has happened. Let's 10 kilometer I have come. Then again you are going back to 0.
All right. Take your submission.
I have come 15 kilometer. Crossing that, again you are going to 0. That day you have asked me brochure. I have explained that. Again you are asking me brochure.
No, my brother.
Allow the
I have-
complete the court to put his question. You
You
initially
put all questions, I will
asked
write.
the candidate.
Yes.
Yes, you may write down.
Yes.
Initially asked the question, instructed the candidate to mention their own category. In the middle, subsequently thereafter, you said that regarding OBC candidate one dispute is going on. That went up to the Supreme Court. Hence, in having regard to the Supreme Court decision, you resubmit the same. Unless you resubmit, I shall be treated you as a general. Ignoring the fact that what you have mentioned in your application as per our instruction. Okay.
Have you finished?
Yes, finish.
Have you finished?
Yes,
Or
finish.
don't say in the means that
No,
I
no,
am
no,
not.
I shall not interrupt.
Don't say in the means I am don't ask.
No.
You have finished.
You give satisfaction.
I am giving an answer.
Yes.
First, I said your Lordship's court must know when this question has to be raised.
No, we cannot ask.
Please,
you
please.
Mr. Bandyopadhyay.
I am saying.
Why?
No. Kindly see.
Mr. Bandyopadhyay.
I am not saying. I have a respect.
You are restricting the court from putting any question to the arguing
You
counsel.
do whatever like. Let me.
I will counsel.
Will you allow me finish my argument in my own way, or you will going on making the question?
Can we not ask a question to you, Mr. Bandyopadhyay?
No. I have no difficulties. My difficulties are.
Then why you are
No,
targeting?
I am not. No, I am not targeting. I have my difficulty, which I have given an answer on the other day. If I have to give again this answer, this is an unending matter.
We are also trying to understand your context.
No,
Don't
let it care what.
say that you cannot ask me that question.
No. I am saying no. Kindly see. I say you cannot ask this question at this stage.
We understood, but
That's
that
all.
query cannot come, Mr. Bandyopadhyay.
Very nice. You can.
Not ask.
No. You can say.
In thousands of matters, we have asked you, Mr. Bandyopadhyay.
If,
I personally, I have asked
let you
that-
finish. Let finish.
Yes,
Then I
we
will give the
are
answer.
pointing it out that when you were arguing in many cases, when you have proceeded substantively, we have again troubled you to answer our query to a particular point which you may have argued. We are wanting to understand your contention. This is our only contention. That this question has come, Mr. Bandyopadhyay, though you have answered it, please answer it once more to us.
May I tell you this? First, allow to
Complete.
make the submissions.
Yes, you continue. Yes. You were there at page 40.
You lordships are more intelligent than me. I can understand. I'm a dumb man.
Page
Both the judges are more intelligent than me. They can rush, but I am not. Let me put my case.
Yes, we are asking you to put your
Yes,
page
then
40.
if you any query, of course I will give the answer.
Yes.
You are not allowing me to put my case. Then I will give all answers.
All right.
I know that your lordships is more intelligent, more judicious, more everything. In that way, I am really dull-headed man. I can understand that. I don't know anything.
We
And that's the reason you are judges, I am here.
pardon your admission to that effect.
Oh, no.
Don't take it to us.
Now, I'm trying to see.
Yes, page 40.
The point is, see here, this is the
Page.
second SLST, page own category, gender of candidates, subject application, academic details. Right? Come to his application. Category একটা application দেখাতো।
His application is at page.
General category কারোর আছে? আরে এই বার করে দেবো আমি এবার।
Original application is at
37.
Huh?
37.
37 or supplementary? Yes.
37 I am placing.
His first application.
What is the category? This is the application.
Yes.
Who has stopped him to say the category is civil caste? Since my Lord Justice Chatterjee was asking me the question. Chatterjee to not.
Because it's application fees which
Then-
you received were
Application fees. Miss Sen, Miss Chatterjee. Now, my Lord Justice Chatterjee see.
yes, no mention about category.
So there was no mention about the category in the.
By him in his application. I will show you the general applications of other. कोई देखिए একটা দেখি না generally. From other matter I am showing because that see the general candidate. Why? I am trying to make you understand, but you
Yes.
page 40. And just this is another matter. Can you see? A general candidate has given this general category.
To page 40.
Huh?
So, Mr. Dhar, you are saying that I mentioned myself as an SC category.
Yes.
Where you have mentioned the same?
Under the rule, it is entirely online. I have no scope to change it. Application, portal, whatever way they make it, and that making is 200, and that's the category at that point of time.
So you did not mention any category,
I cannot mention,
But-
that's a software.
but claiming himself to a candidate belonging to SC category, you paid 200. You paid 200.
I cannot pay 200 unless I click on the category of SC, ST, PH. That was the only thing available online, not in my hand.
Or you allow him to come.
Now, therefore, am I clear to lordship? That's the reason I am saying, can you hear me?
Yes, yes.
Am I clear? Do
Yes,
not be
yes.
annoyed with me.
General is
Ah.
clear.
We are to give.
Do not be annoyed.
Sir.
Thank you.
You are-
Do not be annoyed.
Yes.
Madam, may I tell your lordship, can you do not mind? Do not mind. I tell your lordship. one
No,
thing.
no, no, don't tell anything. You are.
I am coming. Don't.
Conclude.
When we joined in the then please, ST, no scope. What is the next stage? Give the category. Not applied. Next, extended. Not done. Result, declared. Can you come to result?
15 তারিখে রেজাল্ট আরেকটা রেজাল্ট ছিল যেটা লাগাইনি 7 তারিখে সেটা 15 তারিখে হয়েছে 15 নভেম্বর
এটা কোনটা 9, 10 এটা
11 12 পিজি 15 নভেম্বর
আরেকটা কোথায় ছিল 15th?
ওটা 7 নভেম্বর রিটেন এক্সামিনেশন সেটা এনে ওখানেও জেনারেল লেখা আছে
This is 15 November.
পেজ 44
Page 40.
30?
44
This was uploaded on this. He downloaded on 17 December, but it was available.
November.
You said 7th November first. You said 7th November.
রেজাল্ট হচ্ছে 15
15 November.
Acha, 15th.
And prior to that, this is 15 number your lordship is saying, see the
এক্সপেরিয়েন্স 4
category.
জেনারেল
Can you see the category is general?
Yes.
One document he has not annexed, we have also not annexed. Prior to that, on 7 November, we have issued. Correct? Only the marks, that is not the adding one. He has also got it. The written examination marks. Here, written examination plus experience, etc., etc. 15. That was on 7 November. There was also categorized as a general. He didn't challenge, both he didn't challenge. In both the cases, he didn't challenge.
Yes.
Now, my lord, kindly come. Division bench judgment.
পরিষ্কার ছিল না, একটু আমাদের অপোজিশন থেকে দেখি।
My lord, kindly read it from my affidavit in opposition division bench judgment. Page 39 of the affidavit in opposition. My lord, I really committed a fault on that day. Honestly speaking, I am really committed a fault. I would not have done it. I should have been harsh on that day.
Which day?
When this matter was taken up by the division bench. Concession. But I was arguing the matter on merit. I am not concerned about the result, whatever it may be. I have to argue this matter on merit.
Yes, what you are showing?
Now, we have kindly come to judgment of the High Court.
Yes, which page?
Page 41, 42, kindly see. Kindly come to Millard.
41
9.
of your opposition.
Opposition. কোডটা পড়া যাচ্ছে না স্টেপে পরিষ্কার না, ওই জন্য
Yes, 41.
up to 41. Up to 41. Can you see paragraph 1 to 10 was my submissions were being noted.
Yes.
Submissions were noted. Then similar paragraph 11. In course of the hearing of the appeal, we suggested the appellant should open the portal till 6 p.m. tomorrow. Not a single of my submission has been rejected by the court. We, in course of hearing of the appeal, we suggest the appellant should open the portal till 6 p.m. tomorrow, that is December 17th, to allow every writ petitioner who filed a writ petition up to 2:30 p.m. today, that is December 16, 2005, to update their categories. Learned senior advocate appearing for the appellant submits that the appellants are agreeable to do so. What is up? Your lordship says, yes, I have really committed a great wrong by making myself liberal on that day. And henceforth, I have learnt a lesson, no concession in anywhere. After Mr. Dhor's argument.
It's paragraph 20, Mr. Bandhu.
Paragraph 11 and paragraph 12 of the judgment. Therefore, court, what was it?
Ask whether you will agree or not.
No, this is a suggestion. Do it. But sometimes your lordship, not either do it or not. It's not this way. Sometimes,
Yes, we also do. We also request.
That is the way. Instead of request, suggestion has been written.
That is exactly what we told you on the last
No,
occasion.
that is now it is not possible. Now it is not possible. That time try to that
Now you can treat him as an SC.
no. 50 matters will come by Mr. Dhar again or others. Don't. All are in queue waiting in Calcutta High Court, standing with the petition. What your lordships will pass the order. These types of category. Now, my lord,
You tell us
no, I can't do it.
protection you have.
No, I can't do it. I can't do it.
The person exactly similar.
No, similar on that, similar up to that day, not similar today. Every day change of every day in a selection process is a vital thing.
All right. Yes.
Now, my lord, we have considered to this extent, all right. There are so many matters. But we are facing with a 200, 400, 500 matters on this issue, 500, 800 matters. And you know what is the difficulties I am facing now? Now what has happened? I tell you, lordship, the final list which was prepared in the scheduled caste category, who are there, now after scrutinizing everything here, out of 800,000 candidates, 200 candidates have become eligible, 200 candidates have come in the list, and 200 candidates who are selected and whose names were published, they are being deleted. Because his case can be considered. Suppose he is selected. Let's assume in a scheduled caste category, 36 are there. I have published 30 names. Now, if he is selected, last 30 will go, he will reach in 30. 30 will have to be deleted.
No, he's marking. What we suggested was, why did we request?
No, I forget about his case.
Wanted because the domain was kept open that in respect of others, you would be at liberty to consider. We were only on that.
I am kind of done. I am reading that.
If we send it to you, you will suddenly check up this issue. What is his marking? And by granting him,
No.
open this.
No.
This is what we exactly wanted to you.
No.
to answer.
I'm sorry. I have tried. I have thinking about all pros and cons of the matter. Contention up to 1 to 10 paragraph, it was there. Then even I treat him as a general category, he has to give another 300 rupees. Because 200 rupees has been paid for the silk.
He will give.
Generally, he is not coming. Generally, he is not interested.
General, what is the cutoff? You don't know.
General,
How much did you secure?
I got the 49% in the SC category. I got 49.
You got 49.
Yes, that is at page. Page down. Page down. Page 40.
No, you just take
I
us.
got 49.
Huh.
The best candidate in SC got 42.
And what is the general marking?
General is, I'm not in zone, 56.
50.
Yes.
Yes, Mr. Ondor.
Now, similar, we said that if anyone, suppose let's SC, he has been turned into general. Now he has been selected as general from the general category itself. He has paid 200 fees. Then I have to recover 300 fees, rupees 300 balance as general title. Read this argument in this context. Kindly see what he has said. Kindly come to paragraph 18. In such circumstances, in our view, ends of justice would be subserved by requiring the appellants to open the portal for updating the categorization for the candidates who filed writ petition in this regard up to 2:30 p.m. today, that is December 16, 2025. Such portal will remain open till 6 p.m. on December 17, 2005. Kindly wait, my lord. Just. If your lordships want to remain portal only for him, why? Open it for everyone. Of course, I am opposing. Why he is the person alone will get the benefit?
All right. Anything else?
No, no, I'm coming, Milord. Since he has approached the court, that's the reason he is not entitled to other benefits than any other persons. Here in this case, court has said still are there. Who have filed appeal, who have filed applications, all I will show these litigants. Kindly wait. Such portal will remain open till he was now what is how he has managed to get in the verification. Most surprising. Kindly come, Dako. Now then, we have given the public notice on 16 December 2025. Kindly come to page 46. And 910 also we have given 910 also judgments are there. But I am not concerned about 910 here. I am not wasting a lot of time. 16 December. Then he made an what is that?
Portal, page number 47, 48.
Now come let page 48. That means on that date the applications which was the applications which was filed up to the last time of the division bench date is concerned
1612.
correct. WPA 2325. Then
What you are showing, page 48 is of a person whose category is SC.
now see he has filed this page 48. Edited his category. On the basis of that advertisement.
Yes.
Although he was not entitled to.
PC updated when?
Page 48 this is updated on 17 December 2025.
Updated address.
Updated sir roll number, his roll number. Read petition number WPA 2325.
That he filed on 18.
I'm just a minute. WPA 2002-2325. Now he has been asked to appear. Kindly come to 27 December 2025. Next page, page 49. Kindly see second. Accordingly, candidate whose names and roll numbers are given below are instructed to report for verification to answer with all documents relevant to their candidate categories they are now claiming to belong. They must be mandatorily being proved that they filled an appropriate request by 2/3 on 16 December as 16 December 2025. Correct? This instruction was given. At the time of verification, he could not produce even that writ petition which he has mentioned on the application. তাই তো
এটা হচ্ছে ওকে ডাকা হয়েছিল
কোথায় সেখানে লেখা কোথায় আছে ডাকাটার কথা আমি বলছি না রেজাল্টের কথা বলছি মানে তুই যেভাবে বাড়িতে
So this writ petition number is not his number.
no this writ petition was not filed within the time schedule granted by the High Court.
Not my roll number. Somebody else.
Anyway, that's all right.
This is your.
No, this is not my roll number. This is somebody else.
To the seat.
I updated, that's true, but this is not 48 is not my roll number.
Whether your roll number or not, that will, if we can't go in this question, we are questions of repeat.
It is not my roll number.
Roll number, you file a reply and say these things. Have you said so? Then we'll come bring the documents.
My roll number is page 40.
Whatever it may be, sir, you give the affidavit that I am an incorrect document. Mr. Dor, I am requesting you, please sit down. Please sit down. You have taken 3 hours time. I am taking half an hour's time. You will not allow to argue anybody. annoyed, then I will sit. I think that your lordship is annoyed. I should not argue more. No, 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 no. Page 49. দেখালেন?
Must mandatorily be repetition.
Kindly see 27 December 2025.
Yes.
Accordingly, candidates whose names and roll numbers are given below are instructed to report for verification 30th December at 11 a.m. with all documents relevant to their candidates and category they are now claiming to belong to. They must also mandatorily bring proof that they file an appropriate writ petition by 231. It's a mandatorily, which has not been satisfied.
Yes. Yes.
He was not called in the interview. Interview has been finished.
When was the interview finished?
Interview was
2nd January. After very.
2nd January 2026. Only by that time the interview closed. But those who have opted for, in terms of the division bench matter, they have been called on 2nd January 2026.
Yes. In writ petition, did you, right? In writ petition.
Writ petition was filed on long back, 18th December.
Disclose for the Yes, 18th December. Order you disclose for. Yes.
My lord, kindly come to my affidavit at page 13S.
Page 13.
Subparagraph.
Subparagraph.
Subparagraph S to এটা S 5S.
Yes.
Thereafter, on 18 December 2025, the petitioner proceeded to file the writ petition bearing WPA 29125 of 2025 before this honorable court. At this juncture, as well as the petitioner deliberately and knowingly omitted to inform this court of the material fact that he had already fraudulently availed himself of the edit opportunity of 16 December 2025. By virtue of his previous misrepresentation to the commission, instead of placing all relevant facts before this, the petitioner perpetrated a further suppression, presenting his case as though no such fraudulent act or illegally had occurred. He exercised his option that was not disclosed in the writ petition itself. Now, we will kindly come to next paragraph.
Yes.
T. The writ petition being WPA 291 was taken up for consideration and was rightly dismissed by the Honorable Single Judge by the judgment and order dated 22nd December 2025. The Honorable Single Judge, upon due consideration, noted that the process of verification and the personality test for the subject of statistics had already been concluded on 16th December, rendering any relief at that blessing not only untenable on merits but also incapable of being granted in view of the subsequent factual. এটা কি পড়াচ্ছিস আমার ফালতু বেকার কথাবার্তা বলিস না। Now, what is this prayer? Can you come in the writ petition? Well, in this background of the facts, Lord, your lordship should consider the case on the background of the facts when the matter was considered.
22nd.
না কবে ম্যাটারটা নিয়েছি
22 December.
তখন কি বললো রিট কোর্ট আসছে তারপর ফাইনালি অমৃত সিং
Dismiss করে দিয়েছে 22 তারিখে।
Now, can you come his petition, page 29? Page 29.
Yes.
Writ of in the nature of mandamus to issue commanding the respondents, their agents, particularly the East Bengal Central School Service, to reopen their portal for updating the category of the petitioner hearing as a civil caste entity of the ongoing selection process. Then the petitioner. Now, so far this prayer is concerned, my submission is that your lordships would consider this much.
Yes, clear.
Now, on this, my argument would be before your lordships is under what law he is entitled to get it. Leave aside division bench judgment, earlier judgment. The question is a mandamus. What is his right? What provisions of law I have committed a breach? Is there any argument? Yes, this is a branch of breach. Section has committed breach. Therefore, I am entitled to.
Yes.
This is the main relief. The main relief comes to a question of law. Are you entitled in law? Leave aside fact. Are you entitled in law? What law? What law I have committed breach? Why is it a violation of Article 14 and 16? He has not argued.
Yes.
After all, it's a mandamus. Now, the question is, he is asking a consideration on the ground of parity. There is Justice Bosak. Come back to Justice Bosak.
Justice Bosak, এটা একবার দেখ।
আরে ভাই তুই থামবি, তোরা বেকার কথা বলছিস কেন? Now, kindly appreciate this. Justice Bosak was taken long back. Justice Bosak, wait, sorry, the Honorable Justice Bosak gave liberty. Correct? Option was sought for. He exercised the option on 16th. When the writ petition has not been filed in this matter. Quoting a wrong writ petition number.
Yes.
Since he is quoted a writ petition, pending writ petition in terms of the order of the division bench.
Yes.
In terms of that, we have called him. He appeared and he could not show his writ petition which was mentioned by him. Now, what is his case now? This is the very important fact which has been.
What did we say in his reply?
Reply কি বলেছে?
Reply. What did he say?
Reply paragraph 10. With reference to paragraph 10 of his affidavit reply.
You showed us paragraph 5R.
5S.
Of my text. Fraudulent 5S. 5S. Yes. Where is his reply?
Kindly come to paragraph 10 of his reply.
This is from Q to U.
5Q to U. QR is also there. Na?
Yes.
Paragraph 10. With reference to statements and counter-statements, evidence, each and every element then 7 except which are matters of record and has specifically been admitted by further I state as follows. The allegations of fraud is wholly baseless and spurious. The commission alleges that the appellant person, the allegation is denied at this answer. The commission's portal during the edition answer, if the portal was technically restricted only to quantity who filed the writ, then appellant could not have succeeded. The very fact that the commission's own portal required the appellant to make the edit that the system did not have any such filtering mechanism, the commission cannot blame on this answer. Furthermore, the appellant sent an email to the commission for 17th transmission. See how cleverly he has avoided. And his roll number was wrong. What we have mentioned that has not been said in the affidavit. How much fraud a gentleman can commit? He can be deserved to be a teacher. His place should be remain in the prison.
So, Mr. Thor, you did not say that is not my roll number. That is not my document.
That is there on the record here. Have a look at page 48. Mr. Bandyopadhyay is showing.
Achha, we will hear you in reply.
This is somebody else's.
Maybe somebody else's.
Nobody makes an
allegation is-
argument showing a roll
No.
number of somebody else. Kindly look at this. What else?
It may be quoting a roll number, you have done it. His allegation is very harsh.
No. He has annexed a document of somebody else altogether. Because page 48 side by side, keep it with page 42, my roll number.
Your roll number may be different. His allegation is that you have quoted a wrong roll number and referred to a writ petition which did not even you produce when you were
I
called.
can't give a roll number. It is a software. Roll number will be there. Now, my roll number is page 42, ending with 004. Kindly take page 42. For getting a job, nobody does this kind of things.
That is
And-
what we are surprised.
Yes, I am also surprised. Nobody does this kind of things. Kindly take page 42.
This was annexed in their opposition.
Kindly take page 42.
No, your roll number is given. When you were called for verification,
Yes, I gave a, what I did, I gave the honorable division bench MAT number. I also emailed. My only lacking is I didn't file a writ petition.
you visited the commission's portal on 17th. If the portal was, you are saying, had it been
Can I-
technically received?
can I just 1 minute? If you do not mind, just the question would be in this context, whether Riverside, whether he referred any writ petition in his edit or not,
No, I did not.
In his
edit form or not.
No, I did not. I didn't have.
But this is the writ petition.
I gave the MAT.
What is the MAT?
MAT is the division
Lord,
bench.
let him come. May I tell you, Lord, Sister Lord, let him come tomorrow at 10:30, along with his writ petition, which was filed by him before the division bench, the MAT, before the division bench, before the High Court on the date of.
No, that he has admitted that he has not filed any writ petition.
That if he has not filed nothing,
Very good. Now you are referring to this document and arguing fraud. That is what.
because Lord, if, unless one give the reference of a writ petition in the edit form, his portal will not be opened. Portal will not be opened for anybody until he gives a writ petition number which is pending on that day. Suppose I have not filed any writ petition, portal is not open for me. Portal is open.
But then, Mr. Bandyopadhyay, you tell us the roll number that is reflected at page 49
Whose? Yes.
is belonging to such and such candidate, and he have what is his status? Did you consider or not?
Okay, that I will say. Now the question is, well, therefore, did he, my lord, kindly appreciate this. Did he refer any writ petition at the time of edit? If you have said no, then there is no question of opening of the portal for his case.
I gave the MAT number. That's the.
What is the MAT number? You come up now. Show me. Show this court. There your mandamus appeal was pending on that day. Clear to your lordships.
No, he did not. After the date was over, when you were called for verification,
Yes.
you were called for verification pertaining to what? Did you access? Your contention is where from this page 40 has come, I do not know.
Page 48.
Page 40 of your supplementary evidence, which
40.
shows that your category is general. Your argument, is it true? What we have understood you, that after you were admittedly not within those bunch of petitioners who were allowed, and you did not file a writ petition within that time.
Correct.
Now you made a representation.
Yes.
Then why did you approach for editing? You said you approached for editing.
Yes.
You said that.
Yes.
Whether it was, we asked you that was for OBC, why did you go for that?
Yes.
You said that I was totally confused what I will do.
Correct.
So I opted to edit my qualification.
Correct.
So for editing, the portal must have been opened.
Correct.
Master, his contention is, if there was no number of any writ petition,
He's right. I have to give a number.
you have to give a number.
And I have given the honorable division bench orders number because
Which
of
division bench order?
presided over by the honorable justice Devanshu Basa.
That's not.
How can you give your, that is beyond the date, no?
I can. Paragraph 22 has.
No, Justice Devanshu Bosak's judgment was pertaining to or arising out of a separate writ petition. You did not file any writ petition.
Correct. But the division bench directed two things.
Yes.
One,
We understand. Now, how we will ascertain that you put the appeal court number there in this edit option? Then what Mr. Bandyopadhyay is submitting?
this is a extremely hyper technical point taken by Mr. Bandyopadhyay, but I have an answer to
He's
that.
arguing.
Yes,
He's
he
saying
can
that I
argue.
can show you unless
Yes,
the
he
writ
can
petition
take
number
the
is
point.
given.
I am answering to that. My first answer is,
No, you answered, you show us that
I am not finished.
this is, if this is not your document, which one was your?
Lordship, is page
Page
40.
48.
Page 40,
48.
48, it is not my document, that can be understood clearly.
From the change of roll number.
Yes.
But that is not in your affidavit in reply. In your reply, you have not given that this is not my document.
My lord, we thought.
Please bring us that document, Mr.
Yes,
Dhar.
yes. That document, my roll number document is there itself. Page 40.
My lord,
The result of that.
can I say one thing and I,
This is result, their document.
my lord, I
have
will
49.
finish it. Give me 2 or 3 minutes, my lord, I will finish it.
Yes, let it.
My lord, kindly see. Your lordships have suggestion has been given to consider this case. Correct? My lord, if he can satisfy that he has filed any writ petition or appeal,
No, that
With-
is not his case.
if it is not his case, then he is not entitled to get any benefit. Why should I consider his case? I have to consider thousands and thousands. Simply because he has come, he is not a preferred person. My lord, Justice Bosak, appellant was 3 or 4, but opened it for all. And 9-10, similar order was passed by the division bench. The other order. 9-10, he is saying why 9-10? Can you see the similar order? Konta? My lord, kindly take.
Same day.
On the same day.
All right. Anything else, Mr.
My lord, I have nothing to say. I have finished. My lord, one judgment I will show. Joseph Keto. Konta? My lord, kindly take it. Supreme Court judgment. Martin? My lord, paragraph 14 kindly come. Go, bole. What follows from the, my lord, can I read, my lord?
Yes.
Paragraph 14. What follows from the above decision is that irrespective whether any aspirant for public employment belong to a particular community like SC, ST, OBC, the status claimed by him for being accorded to 14 is not.
Yes, what?
What follows from the above decision is that irrespective of whether an aspirant for public employment belongs to a particular community like SC, ST, OBC, the status claimed by him for being accorded to the benefits of reservation is per se not decisive. Such status has to be certified by the competent authority upon followed due process and identification that the aspirant is what he claims to be. In so far, the requirement of production of a certificate from the competent authority was held to be mandatory in view of statutory mandate. Although there is no such statutory mandate in the factual presence, the requirement in question is no less mandatory and must be scrupulously followed. Once a process of recruitment is set in motion, all aspirants are entitled in law to equal treatment. There cannot be different yardstick for different sets of aspirants. Non-compliance with the terms of the advertisement notification is bound to trigger adverse consequences of rejection of the aspirant's claim. Status by the selecting body appropriate authority should be choose not to adhere to the same. Having regard thereto, the selecting body appropriate authority would be justified in not entertaining the application of an aspirant as a member of the community for whom reservation are permissible. Then now let kindly come to paragraph 19. Paragraph 90, can I read, Miller? Paragraph 90. It is no longer res integrata that terms of an advertisement issued in connection with the selection process are normally not open to challenge unless the challenge is founded on the ground of breach of Article 16 of the Constitution or for that matter, Article 14. Once an advertisement is issued inviting application for the public employment, it is a responsibility and a duty of an aspirant to read and note the tiny terms of the ambiguous requirements are. If any aspirant finds any of the terms ambiguous and there is a scope for an inquiry inbuilt in the advertisement or is provided by any rule regulation, an effort
ought to be first made to obtain clarity for understanding the requirements accurately. If no such scope is available, nothing prevents the aspirant from seeking clarity by making a reference. Should such clarity is not provided, the aspirant may participate in the process without prejudice to his rights and may question the term even after he is not selected. However, if the aspirant does not make any such effort and takes a calculated chance of selection based on his own understanding or the disputed term in the adversarial and later, he emerges unsuccessful ordinarily, it do not be open to him to challenge the selection on the ground that the disputed term is capable of being understood differently. In such case, the court should be loath to entertain such pleas of ambiguity, which preferring to accept the recruiting authority's understanding of the said term. This is for the simple reason that the recruiting authority is the best judge of what is required and it is such understanding of the recruiting authority that would matter most in cases brought up before the court. Hence, after commencement of the process, wherein aspirants have participated without raising any demur as to what a particular term means, even in any terms, the court should lean in favor of the particular. Therefore, my lord, my humble submission would be, my lord, kindly see what, by this time, selection has been completed.
Selection has been completed. What is the counseling
Counseling has begun since yesterday.
and his
Yes, maybe, but
counseling for that subject has not.
may not be. But every day of this subject, 24 yesterday, today is different subject. He is not concerned about this subject. There can be not any dichotomy of any facts. He has not started. Therefore, how you give it this? Ice has not given water to give it to me. This is not. The question is right. If I have committed wrong, even if statistics, orthopedics, whatever it may be, court will set me at right. If he is not entitled in law to get in, whether it's
Written test and interview is also there in your.
he was not interviewed.
What
Therefore, your lordship, if you grants today, one has to put the clock back up to the stage of interview.
So he got 49 excluding interview.
No, 49
Excluding interview.
49.
Including and it's
Interview, how much marks is there?
20 interview.
Interview 20.
So without appearing in interview, he has scored 49.
49.
It's a fact.
Yes.
All right.
But he is comparing his interview marks only with the scheduled caste. In general,
He is considering his written test 49 with other scheduled
scheduled
caste.
caste.
So after interview, what is the first scheduled caste candidate number?
Kind of just give me one second. কত
প্যানেলের
বল না 42 56.75
ফাইনাল প্যানেলে
after interview final panel 56.75 only the interview not final panel 56.75
লোয়েস্ট হচ্ছে
and lowest is
First candidate,
yes
56.75.
and lowest is 42.25 general scheduled caste
এসসি
আর জেনারেলে কত কোথা থেকে শুরু হয়েছে
জেনারেলটা মেল ফিমেল 78 and 75
and general milord in general 88 highest and lowest is 75.50
General is 83 highest,
88
88 and lowest is
75
75.50
thank you, Mr.
deep level can my lord just strategy kindly not mind please Mr. Justice Chakraborty also kindly
Mr. Bandyopadhyay, you are concluded their arguments. Is the matter as
All request, there is a series of matters starting from the next item up to 15. Now at 2 p.m.
No, no,
before
yeah,
the
today counseling is on.
Yes.
Yes, yes.
Internet subject. No, no, important.
not in this subject, my lord, not in statistics. Next item up to 15.
8 to 15.
Sir, বললেন 15 অবধি না। এটা প্রাইমারি এটা। 9 আছে।
Acha, Mr. Dhar, you can show us that page 40 which Mr. Bandyopadhyay showed.
Yes, here and now I can show from their own result. That's they, in fact, they never said it is.
We are asking you something.
Yes, yes.
We are asking you, is that document available to you? That you put the mat number and
No, that is in their portal.
We will
And
produce
they
it.
never said in the parent.
We will produce
They
it.
can
We will produce it with
produce what?
his actual edit.
His one you can produce.
I can
Yes,
produce.
this one was
At
not
2 minutes I
mine.
will produce. At
They-
2 I will produce. 2 p.m.
He produce what? That page 40 is not his. He say.
48 is not mine.
Different roll number. My mistake.
That's I'm saying.
Different.
Roll number is different.
Page 48, they have annexed for somebody
Page
else.
48.
If he put mat number, that is not. But if he put any false repetition
Then I am
number,
out, of course.
to show himself that
I'm-
I also
Correct.
filed a repetition prior to that,
That would be fraud.
that is wrong.
That would be fraud. Correct, correct.
People
That
have,
would be
That
fraud.
would be fraud.
people have
I
given
am
mat
not-
as well. People have given mat which they have filed. He did not file that mat also.
No, I know I have not filed
Many
that.
people have given mat number. We have accepted if they have filed from read. They have filed
Who
mat
were within that time schedule.
within that time schedule. Even that mat was not filed by him. That is our contention. He did not institute any litigation
No,
before
the
this.
mat number which is given, that is the mat number here.
Justice Bosak.
Justice Bosak.
Which he was not a party.
Yes, I was not.
It was not a party. That's admitted fact.
So then he has this argument that he has practiced fraud. This is not sustainable.
Because in our notice we have said you have to mention your own writ petition or mat which you have filed
What you have said.
in 16 December notice.
I dekho, file টা।
There cannot be any question of other man.
Page
Page 46 of our opposition.
page 46 of
Of the, may I, your Lord,
page 46.
of the opposition.
We have page 46.
Well, this is to notify,
Yeah, just
I'm sorry.
passed in mat such a, so he gave this mat number and applied.
Yes. Well, this is to notify all concerned that in compliance with the solemn order dated 16 December 25 passed by the Honorable High Court at Calcutta in Mat 2115 of 2025, only those candidates applying for classes 11-12 assistant teacher in second SLST 2025 who have filed with petitions regarding change of their respective categories before 2:30 p.m. on 16 December 2025 shall be allowed to edit their categories.
How did you allow editing?
My lord, we opened the portal.
Yes, that was, he was not a party to that
So
proceeding.
therefore, my lord, he had to, he was not a party.
Was not a party, but after page 40, when it came down, which he downloaded, page 40 of the supplementary affidavit.
40. The supplementary affidavit.
Which he
Yes.
downloaded.
So
he
just
said
give me
his
2 minutes.
category
Just
came to
give
be
me 2
general.
minutes.
But that is a different document.
Well, that is a different document. Annexure R7, your lordship is looking at page 40, 48.
This is a different.
Classes.
সেখানে ও যেটা বলছে হয় ম্যাট না হলে রিট পিটিশন, সেটা নয়, মেনশনিং অফ রিট পিটিশন ওয়াজ ম্যান্ডেটরি।
My lord, as
Meaning of
my learned,
petition was mandated.
yes, yes.
Page 47 তারপরের পেজেই আছে।
Correct.
তারপরের পেজে
The reason I filed the
petition number.
thereafter. I didn't file a writ petitions prior to that.
Enter rit petition number.
I-
So it is mandatory unless any such rit petition number is put. The subsequent.
And the writ petition has to be filed in your lordship's court within the time earmarked by the honorable division bench. By the petitioner, someone has to file a writ petition. My lord, what happened, my lord, Mr. Dhor was the arguing counsel for the appellants there also. But we were the appellants. My learned senior friend was appearing for the respondents. My lord, a window was directed to be, or rather, my lord, a request was made over, or a decision was directed to be taken from the commission.
He wanting to learn.
My lord.
Writ petition mentioning was a mandatory thing,
Yes.
and he had given on the appeal number in which was not a party.
Yes.
You treated him to be general.
Yes.
Including verification.
No,
During verification. When he came, when we asked him to give the writ petition number, he failed to give it.
27 তারিখের এটা এটা এখানে লেখা must bring proof.
Verification again, rit petition.
My lord,
Proof that you have filed a rit petition before that date.
my lord, kindly sees page 49 of the opposition, kindly sees once. I may be incorrect, my lord, just showing your lordship, my lord. Please see 27 December 2025 document. This is to notify for information of all concerned that pursuant to the notice dated 16th December, 16th December is page 46, issued by the commission in compliance with direction, a solemn order dated this of the Honorable High Court dated this, in mat number this, candidates who had filed writ petitions up to 2:30 on 60 were allowed to update their categories up to 8:30 on 17. Accordingly, candidates whose names and roll numbers are given below are instructed to report for verification on 30th December. My lord, they are mandatorily bring proof. Kindly read that sentence.
Being at 2 p.m.
Yes, yes.
2 p.m.
What do you mean?
আমি চেষ্টা
My lord, he is trying, my lord, he will definitely try. Definitely, my lord, take, my lord, whenever it is available, my lord, he is,
Do you want more time?
by the end of this day,
আমি চেষ্টা দিয়ে দেব।
my lord, by end of, my lord, the working hour,
We will ask him to come also.
4 o'clock, 4 o'clock. Keep it at 4 o'clock.
There is a matter fixed before the Honorable Chief
Your
Justice
junior,
at 2 p.m.
4 o'clock, Dada, 4 o'clock.
I have no problem. Once I am not there, I will come.
No, once I am not there, bolo na, 4 o'clock rakho, he will come.
Only he will come and give our.
Yes, yes, 4 o'clock.
Send a copy to Mr. Mike.
My lord, he is going to send a copy to my learned friends, junior or Mr.
And
my lord.
I also make it very clear, if I make a repetition number, of course, this would be completely incorrect.
no, he did not give any writ petition number. He
That
gave the
is
mat
my
number.
instruction. I have given MAT because that's the judgment
When
by
the
which
writ
two
petition
portions.
matter
I'm
was
seeking discretion
mandatory required to be given.
My lord, my mat number also he could not have given because
that we
that was not the only mat which was
That
taken
we
up.
understand. But since he did not give a writ petition and was not within the domain of the appeal court, you treated him to be a general candidate.
Yes, 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 yes. That is our sum and substance. You know, during verification, when he failed to produce.
We will pass our order on that. And we will record that you have said that his reference was pertaining to a appeal court number, sir. Yes. Then not required day after tomorrow when we will be passing the order, you give it to us.
ठीक है, very.
Chalo.
Day after tomorrow, 1 p.m. your lord has been kind enough. 1 p.m. my lord has been kind enough.
From next matter to up to item 15, since my lord, there is a matter fixed before the Honorable Chief Justice as 2 p.m. Can it be adjourned for the day?
7 to
15, 8 to.
No, Lordship, not 8 to 15.
8, 10, 11, 12, 15. Same judgment.
No,
Item number 13 is not.
9 is a different one.
8, 10, 11, 12, 15.
11, 12 তুমি আছো?
আমাদের মধ্যে
8, 10, 11, 12, 15.
after 2 weeks দিয়ে দিও yes
Well, 2 weeks. Then I'll be in difficulty. And adjournment for kindly make it not today. Well, because of the interim order prayer, this was
কবে না
today might Kindly not
today is Tuesday
8, 10, 11, 12.
Wednesday next Wednesday
next.
No, next Wednesday holiday. But after Holi.
mention at 2 p.m. That is why we will keep it on 10th.
Then that's your loss. Right, 10th March.
show us the what he submitted with the appeal number.
I haven't told my lord, I will
And
ensure.
Mr. Vadai, what is the lowest mark of the SC?
42.25
No, 42 point something.
Last person was 42 point something.
He is in schedule caste, he is no doubt, he is with the top position. There is no dispute on that.
No, but he without interview, how can it be?
No, he has not given in the written test, he was no doubt about this. I don't know.
No,
But
that
what
we
I can do, my hands are very tight,
understand.
were very tight. Hands are very, and he has come at a very late stage. Very late stage. That is another problem, my lord. Everything has been, my lord, I normally, believe me, for God's sake,
Okay, we
yeah, I
understand.
try my level best. But in one place I have to stop one. I try my level with these types of order. You have seen that Justice Bosak's order. That is because of I requested the chairman, do it please. That day I requested person. Now the time has gone. Time is a great factor. Otherwise, I have what is mine, my lord? Either X will come or Y will come. What is there? I have nothing to difficult. There are certain problems. My lord, I have been told. My lord, I have been to, and another problem is since I considered there, 200 persons amongst them have been selected. The moment 200 persons have been selected from the select list, someone right of someone is also going. I have to take care about that also.
We will consider, Mr. Vadai,
Huh?
but as
No,
we
it's
have
all.
kept it
But
as
only one thing that I think the matter will go on, this land matters.
yes, which matter is yours?
Not mine. Mine matter is 9, na? That will not be, other side will take up time. Then 13, 13, 14, 15 is mine. But my lord, I have a special bench matter at 3 o'clock.
No, 13, 14, 15 is not yours.
Not matter. 13, 14. 13, 14.
Because 8, 10, 11 and 15 we have kept it on 10th.
Yes, 13, 14.
Yours is 9 and 13, 14.
9, the other side will take time. I am the respondent. 13, 14 also respondent, but
একটা note করে রাখো।
13, 14, my junior will be here. But only I have one special bench matter at 3 o'clock. Otherwise, I would have finished today. Deeply obliged to us. Deeply obliged. Prize, kindly. Please. Justice Chakraborty. I'm not bad man that way.
Item 29, my lord. The last order was on 6th January, my lord. Lordship's direction was, my lord, that I should come up with the written notes of argument. The petitioner has already filed written notes. Today, I'm supposed to file my written notes. So far as item 29 is concerned.
Then 31 letters here, Mr. Basu.
And my lord, no.
He replying with it.
No, lordship, may I?
He is to file the written note only. Let him file it.
No, written notes, my lord, and lordship may kindly have a look at the order of dated 6th January, my lord, 6th January 2026, and clarify certain points issues raised by Mr. Basu in the reply argument.
Alright.
Certain
Take much time.
only 5 minutes. Only on 2 issues.
Yes.
I have already covered it in my notes of argument. Only, my lord. May I respectfully invite your lordships, my lord, to the written notes of argument filed by the written petitioner, by the writ petitioner. Written notes of argument filed by the writ petitioner. May I respectfully invite your lordships, my lord, straight away, my lord. My lord, may I respectfully invite your lordships.
Page 65.
Page written notes of argument, lordship got, my lord. Page 5, my lord, of the written notes of argument. Page 5, my lords. My lords, paragraph, my lord, 6, my lords. Here, my lord, a point has been taken which is not at all present throughout the pleadings. Suit lands enmeshed in the said proceeding are admittedly non-agricultural lands and thus goes out of the domain of the West Bengal Estate Acquisition Act 1953 and the West Bengal Land Reforms Act 1955. It is a settled principle of law that Section 60 of the Act of 1953 applies only to mill and factory which was actually in operation or was functioning on the date of vesting. Mills and factories closed long before vesting, there could not be any question of vesting under the said Act of 1953 as well as the said Act of 1955.
He has argued.
So this was argued. This was argued, but whether the mill in question was operational or functional on the date of vesting,
That you have opposed.
that is, my lord, that is,
You have given a reply to these arguments, saying that the issue of operationalization, this issue, whether it was in operation or not in operation, that was not said. That is something.
yes, throughout the, if your lordships, my lord, if your lordships are kind enough at the time of delivering the judgment, go through the pleadings of the original application before the learned
Your
tribunal.
contention is this point was not there in the pleading.
Not at all. That is one. And secondly, one judgment has been relied upon. One is Juhi Finales, which is already after Supreme Court review application is pending. Here I have given the status of the review applications also in my written notes of argument. It is pending. And so far as the BRC construction is kindly sees one judgment. This is also BRC company, construction company, this judgment. I'm referring to page 6.
Yes.
This is also, my lord, after admission of SLP, the civil appeal is pending before the Honorable Supreme Court. This BRC company case.
BRC, we have now written.
Oh, I'm telling as on date as status. BRC case as on date, it is pending before the Honorable Supreme Court. The SLP after admission, the number is civil appeal and it is pending adjudication.
Yes.
I have given the pending status in my written notes. I will hand it over.
PRC is pending.
Lordship. After SLB, it has got the number of CA, civil appeal, it is pending. Not only that, in BRC case, Lordship will find that there the vendor was a recorded riot. But here, the vendor of the petitioner was never a recorded riot. This is a fundamental difference. Now, second clarification, Miller, if I may give, second and last, Lordships, may I respectfully invite your Lordship, Miller, at page 9 of the written notes of argument. Page 9, Milord, paragraph 12. It also deals with two judgments, thereby saying the said adjudicating authorities, including the learned tribunal, while examining the rejection of the second application for mutation, completely overlooked the aspect that the non-agricultural lands which, if it at all vests, may vest under section 3A of 1955 with effect from 9th September 1980, even if, assuming such non-agricultural lands to be vested in the instant case, it would never vest, as it is far below the ceiling limit, as in view of circular dated 14 September 1994 issued by the Office of the Director of Land Reconnaissance Survey and Joint Land Reforms Commissioner, Government of West Bengal, which has been already annexed to the original application, presently at page 130 of this application. Notification had obtained judicial sanction while deciding a second appeal in a judgment reported in AIR so and so, so and so, so and so. This is out and out a misconstrual of the judgment reported in AIR 2000. Why? Because the circular dated 14 September 1984 was never given a judicial sanction. Rather, there the appellant referred to this circular. And finally, the appeal was dismissed also. So it was a mere reference or relied upon by the learned counsel for the appellant, not the judicial sanction given by the learned judge dealing in second appeal. That was not a judicial sanction. Referred by the learned counsel for the appellant, that's it. And finally, the appeal was dismissed also. Lord, she will see the judgment also. So these are the two, Milord, clarifications, Milord. May I, Milord, my respectfully, Milord, file my written, Milord, notes of argument. Lordships. I'm giving a copy to my learned senior friend also, Lordship. Matters, Milord, may I respectfully state this, Milord. Lordship, the other two matters, WPLRT 69 and 70, Milord, those two are issues are completely different from this issue over here. So, Milord, Lordship, Milord, let it be finished. But, Milord, my humble, Milord, subject to your Lordship, certainly correction, that these three matters cannot be governed by one judgment.
No,
So,
we will not govern it by one judge.
Lordship, 60.
We wanted to hear what would have been the objection as regards Mr. Basu's claim in this two. That is why we will deliver three separate judgments. But as analogous issues are involved, we want to.
No, issues are not.
No, that was his.
This is my submission. Point of law is same.
No, analogous.
I'm not saying analogous. Point of law is same.
No, not even same, Milord. I have gone through that. That's why I came to know.
Let me you have a turn.
We will close the hearing of the three matters together and deliver our judgment.
Lordship.
It is concerned, my lord. Let Mr. Basu conclude. Let's take conclude.
How many?
No.
No, it was a, this is the part to say, these matters, my lord, other matters, my lord, were taken up by the days together. My lord, these are the two, my lord, 288 pages writ petition. I think, my lord, I will not place it.
We have given notice to you. That's not very your time.
He has some difficulty today, my lord. He has some difficulty.
Again, we will place it again.
Any day, one day, my lord, he will conclude. I have instructed, my lord, any day, let my other, my lord, state and my lord petitioner conclude.
We cannot risk every day.
One day,
Definite period, a matter will go on.
these matters are
Because again, you will argue.
I will not take much time. The similar point I will urge. So I will not take much time.
You should need the upper resolution. And you are there, sir. You can also argue on this basis.
He has been arguing, my lord, for the
We have 4 times it was told us Mr. Sengupta is appearing, Mr. Sengupta is appearing, Mr. Sengupta. So, how long can we say?
these two matters were never taken up, my lord, before that. Taken up.
How can it be taken up? He was said that he has concluded his arguments. He said that the matter is similar. And we fixed the date taking consent from you.
He is scheduled to appear, my lord, he has some difficulty.
In the meantime, you find out when it will be suitable and give us the date. Meantime, find out. How many times, sir? You don't have any slot at 2 p.m. fixed. You are insisting, sir. Please argue and please.
Sir, kindly, my lord, this is my predicament, my lord. He has been arguing since 2019 in this matter.
We have given you 4 times that Mr. Chaudhary tell us when he will be available. He is such a senior counsel. He has to appear and tell us. We cannot close the hearing also. If there is no assistance, then it becomes. Today we will fix it after 10 days. You will come and say that.
No, kindly, my lord, record this, my lord.
Exactly what you said when you fixed them.
My lord, if my lord,
Anyway, Mr. Basu.
my lord, kindly record, my lord, if my lord,
Yes, Mr. Basu, which matter will file the audit file? Una written argument. Yes, open. Your written argument.
I have already
70.
In 61 WPLRT.
Huh?
I have filed my written notes.
Where is
Lord, she kindly record a separate order, Lord.
Have you given one? Order
For everybody, not only for me.
or এমনি হবে অর্ডার না হলে হবে
না এটা হয়ে
না আপনি দিলে পরে দিন
there are other private respondents also.
we are not concerned. Nobody is appeared.
have to repeat. It is in your lordship's mind, my argument in that matter. I will repeat.
You are taking 69.
69. 69 and 70 consequential order.
Yes.
Because if they sought to correct the record of right, that was challenge also. Now, my lord, on the basis of admitted fact which are there, if a land is to be vested under the Estate Acquisition Act, two ingredients has to be fulfilled. One is the person who was there on the cardinal date is in excess land than that of mentioned in the Estate Acquisition Act. First thing. If there is no excess land, there is no question of manifesting. Why I am arguing this? Because in our case, my vendor had no excess land ever. Another thing is, my lord, under section 6 subsection 3, vesting will occur if a person have excess land and allowed to be retained for the specific purpose of ABCD, mill, factory. So, if these two ingredients are not fulfilled, a land cannot be vested. This is the bare scheme of the Act under the Estate Acquisition Act. This is known to my lord. In this case, admittedly, just a minute, madam. Excess land. This plot was purchased by my vendor in 1957. And we take this date, crucial date. This is post Estate Acquisition Act came into force. Now, kindly see the order which was subject matter of challenge at page 207 of your lordship brief. Yes, 207. In the trial court.
221. 21.
No,
59.
this I will come later. This I will come later.
Okay.
Because this is subject matter challenge before my lord. I want to show to your lordship the genesis.
221 is
the order of the learned tribunal against whom we are before my lord.
Yes.
Kindly keep it aside for the time being. Kindly come to see the record of right first. 185. Five. Thereafter, 185. As my lord kindly got it. Because the interpretation of the record of right will lead to the ultimate conclusion of your lordships. 185, kindly come to the right hand side. Is Daholkar. Then. Offending portion is then. Bhumio Bhumi Rajaswa Daptore Sajansa 6-3 Dharaye. As well as kindly count the next record of right, it is clear. 187. You can read it. The status is Rayat City 1. Got it at the right, and kindly come to the bottom, the middle column. Bhumio Rajaswa Bibhager 21-10-63. Kindly mark this. তারিখের 18/6 আদেশ অনুসারে 18094 দাগের শতাংশ জমিদারি গ্রহণ আইনের 6-3 ধারায় রক্ষিত। My basic question to myself is, to apply 6-3, it has to be shown that it is a mill, factory, garden, orchard, and are allowed to retain. Can you test my submission? From the four corner of this record of right, What my lordship will get? Kali turn over the page. Your lordship will get in Niskor, Rai Sidiban, and next page is Dalan. Am I clear to my lord? I repeat, my lord, two things. One is has to be excess than that of the prescribed under the statute, and on the date, the cardinal date, there was a mill or factory that was running. That's why is allowed to retain. Mill closed, give it back. 6.3 will apply only in case of a mill factory was in operation on the cardinal date, that is 15th April 1955. This part probably I am clear. Now, why we have challenged that? This insertion. This insertion, my lord, where from this insertion jump in? If the record of rights showed that there was a mill running factory on that date, and now it is closed, so 6.3 it was allowed to retain, made the entry, and subsequently it will be resumed. I have shown to your lordship, there is admitted document. Here my lord will not find anywhere that there was a running factory on the cardinal date. So basis of an vesting under section 6.3 is absent. Yes, we have challenged this order. That they cannot plan that too in 1963. Date is also helped me. In 63, this order has been passed. We have challenged this order and approached the authorities ultimately with the LRTTSC. And say your name, say your name.
Resumption order.
Resumption, insertion. This is not the resumption. So, we challenge this order. That why in the record of right you have inserted in 1963 that this is returned land of 1963. We have challenged this order. Ultimately, my lord, now I am bypassing everything. Now kindly come to 2021, my lord.
What happened to that challenge?
My lord?
What happened to that challenge?
Yes, that challenge.
It would be under section 44.
Court directed no. Court directed.
Then appeal to the district judge.
Court directed to consider. Now the consideration I will come, which was subject matter of challenge before the learned tribunal. 207. Kindly come to 207. After this. We challenge that you cannot insert it because we have purchased the land in 1957 and the mill started operation, a new mill started in operation in 62. 61 এর মধ্যে 61 ঠিক আছে. Now kindly come to 207. The first line is an attempt to camouflage. Why I am saying? Whereas an area of more or less 406 acres of land comprised in the mill as held by Grand Smithy. This mill is subsequent to Estate Acquisition Act. Because I have shown to lordship the record of right. There is no whisper of any mill. Now, kindly let us proceed further. Under police station Bali in district of Howrah vested in the state government free from all encumbrances under section 5 of the West Bengal Estate Acquisition Act. And whereas the state government allow the said mill to retain, the mill started in 1962. question of allowing under the Estate Acquisition Act does not arise. Am I clear to my lord? And whereas the state government on inquiry have found that the said area of 400 acres of land is not used by the said mill or this purpose for long. And whereas the Honorable LRTT such and such giving opportunity of hearing to the said mill being the appellate of such and such. And whereas the state government considered necessary to resume the said area of 4 acre of land being surplus to the requirement of the said mill for its purpose or which it was so allowed to retain. This only can happen if you allow me to retain. If the vendor has the excess land and allowed to retain for a purpose closed, can be resumed. Language is like that. But kindly keep your lordship's mind, this mill after purchase started in 1962, whether this language used, this language which has been used in this
order under section 6(3) of 1963.
My lord?
Come second paragraph.
Yes. Yes, that I'm saying. Can 63 order can be passed unless there was mill was in operation on the date of vesting. Presumption will be on that date you have excess land, mill was running, so you are allowed to retain for the purpose of mill. These ingredients has to be there. Record of rights specifically said no existence of any mill or factory. It is a dakholkar, dalan, and other category also there. My lord, when I will place that, I will show to your lordship. Danga, dalan, there's so many things was there. Record of right will show.
Yes. Non-agricultural land in nature. Non-agricultural land in nature.
Land in nature.
In whatever name it is recorded.
Now, I want to show by saying this that there was no existence of mill.
Yes.
My lord has seen so many record of right where he said is a karkhana. Karkhana was not there. So 6(3) by no stretch of imagination can be applied. Coupled with the fact, on that cardinal date, my vendor had no excess land beyond ceiling. I repeat, my lord, pardon me for repeating. Have to be beyond ceiling land excess holding and running a mill or factory. That's why you are allowed to retain. And the purpose closed, factory closed, bagan closed. So give it to me. State government can say. If these two ingredients are not fulfilled, my lord, in my humble submission, the Estate Acquisition Act has no manner of application.
Okay.
Then may I read that? And whereas the state government considered necessary to resume the said land, and whereas the state government issued notice upon the said mill as well as the concerned having alleged interest in the said land for giving an opportunity of being heard, and whereas all concerned including the constituted attorney of the said mill appearing in the hearing, and whereas the state government after considering all the facts and circumstances of the case is satisfied that the said area of such and such land is no longer required by the said mill for the purpose of running the said mill. Well, because my mill, my factory, it may not be required. How state is concerned? If it is below the ceiling limit, I'm asking the question to myself, not questioning the court. If I find that this part of the inquiry of the state government is correct, I don't require land. It is kept vacant below ceiling. What is the business of the state government to say?
Yes.
Shall we turn over? Now, therefore, in exercise of the power conferred by the first proviso to subsection 3 of section 6, the governor is hereby pleased to resume the said area of such and such of land as detailed in the schedule below. Then such and such and such. This is the schedule of land. Bali, 2 maujas are there, Barakpur mauja and Bali mauja. Nowadays, my lord, it appears, my lord, I is a presumption of mine, that when the state government said there was a mill and stop, irrespective of the fact whether there is excess land or not, is to be resumed. Now, to that, my lord, another document I want to show to you, lordship. Kindly turn to page 245. 245. I need to sell some land of that which the state government says I am not required for the time being. We applied before the authority. What the authority said. Settlement charge officer, Howrah. The date is 29th May 1963.
Yes.
Can you allow me to read? With reference to the memo quoted above, I am to state that on scrutiny of the big rights register and records, it appears that the vendor who have transferred the land in favor of Messrs. Gansmithy, my vendor, works are not big rights. Record shows that they possess a small quantum of land in the district, and of the said quantum they have transferred land in favor of the said factory only to meet up financial stringencies. Obviously, the lands transferred by them are not surplus to their requirement. Had it been the case where I gone for admission for transfer, they could have seen that this is excess land of by selling off by the vendor. So you cannot transfer it. Because if it is surplus land, now the clause, it has to be resumed by the state government. Now see what they're saying. It is not a big right. Quantum of land is very less, meaning they are by below ceiling limit. And so their transfer is not hit by anything. They allowed me to transfer. In my lord.
Charge officer. What is charge officer?
Probably under the estate acquisition act. Can you see this top?
Whether he is any authority under Estate Acquisition Act?
My lord, it appears so.
Estate Acquisition Act has used the word charge officer.
Well, kindly come to the above. The settlement charge officer, Howrah. To the charge officer, Howrah. This is the government document, my lord. And he consulted the records and it appears from the and certify that they are not big right and their land is quantum is less.
Okay.
I have shown to lordship, my lord, the quantum is less on the from the record of right. It is in addition to that. Now, my lord, I want to show to lordship that petition paragraph 7. Well, I am apprehensive because on the other matter, Mr. Kalim has pointed out the question of pleadings. Kindly take trouble to see page 6, paragraph 7 of the petition. May I read for you, lords. That from the records of right, it will be evident. Chakraborty can got it. Record of right, it evident that the vendors are described as Dakholkar, Akrisipoja, Rayat, Sitiban, Dakholkar, Chirosthai, and Dakholkar, Bosotpoja. None of the aforesaid lands of the properties were recorded as factory at any point of time. The nature of the properties was classified as Doba, Danga, Bastu, Udbastu, Pukur, Pukurpar, Bagan, etc. That on perusal of the deeds and relevant finally published record of right, it is evident that the vendor of all the plots were described as Dakholkar and such and such, such and such. Then kindly come to paragraph 8. On perusal of record of right, it is clearly evident that subsequently, after final publication of record of right, it is mentioned on its face that the plot is retained under section 60 of the West Bengal State Acquisition Act. Any subsequent noting in the finally published record of right is also subject matter of challenge in the present petition. It may be specifically be noted that at the time of final publication of the record of right, that all the vendors of the plot purchased by the petitioner were described as such and such. Any subsequent noting does not make any effect. This is our case. Now let us read, my lord, on this facts we want to quote that the subsequent insertion is bad in law. And we have also shown to the court that the genesis, that a vendor has no excess land, so by no means it can be. And the subsequently established, it was established, that documents are also there. When the factory was established on that land, that is in 1962. After 62 onwards. So even on that score also, there was no existence of mill on that plot on 14th April 1955. On these facts, my lord, we approach the authority, and authority passed this order I have just now shown to your house. That they thought that the running mill means it was there on that date. And said that this land is in excess, they are not utilizing, so resume it. And I will cite, my lord, already cited judgment is other matter, that only first condition is there has to be an excess land vis-a-vis the State Acquisition Act. The quantum if excess, then these conditions will come, otherwise not. Now, my lord,
How the learned tribunal dealt with this issue?
Yes, that I am now coming to that issue. Longest judgment, my lord.
11, take us to the 11 portion.
Page 221. Will kindly come to 221, my lord has reached.
220.
Yes. Whenever such and such are taken up or passing such and such have
One
been.
is pertaining to the other. You have preferred to read petitions.
Yes, because to consequential one. This will suffice for my lord. Yes.
Because there were two original.
Yes. Have been heard analogously on several dates, interrelated, and myself, such. The OA number such and such was filed with the prayer for setting aside the order dated 20th March 2015, passed by the Additional Chief Secretary of Land Reforms Commissioner, and also the order dated such and such, passed by the Deputy Secretary of the Government of West Bengal, such and such. Whereas the OA number 1477 was filed on such and such date, challenging the notice at page 75 to 80, I have shown to your lordship, of that OA, which were issued for correction of record of right. Not only they stop there, they have to correct the record of right. If this is valid, this is good, then consequence is they have to correct the record of right. That also you have challenged, consequence here. A bench, after taking into consideration of the submission of both the sides on perusal of material document on record, pass the following common direction upon these parties. We have considered the submission made by the parties, peruse the record of materials lying therein. Admittedly, the respondent state is claiming to have taken possession of the vested suit property and have made necessary correction in the record of right. In pursuance of the relevant order passed in section 6.3 proceeding, it goes without saying that if third-party interest is created in the disputed property during pendency of the application, the future complication will arise, causing prejudice to the petitioner. We are of the opinion that neither of the parties will prejudice if there is an order of status quo on the date regarding possession and nature and character of the suit property is still making the still such and such date. Now the Belur Somoji, we heard Mr. Sengupta is appearing. They were sought to get the possession of the land because if it is excess vested to the state, they can do whatever they like. Belur Somoji Hospital was sought to be given this land for their purpose. Already one part is there, but secondly, now Belur Somoji such and such has been implemented as a party respondent in both the way. By an order dated such and such of this tribunal, Srimati Susuma Goyal and 5 others also filed MA for addition of parties, being subsequent purchaser of the subject land, and they are also implemented as party respondents without prejudice to the right of the parties as per the order of such and such. It may be mentioned that the present applicant had also filed an OA before this tribunal with a prayer for setting aside the notice dated such and such issued by the sub-divisional land and land reforms officer, Howrah, in connection with conducting reconstruction survey in respect of the self-same land allowed to be retained under section 6(3) of the West Bengal Estate Acquisition Act. By an order dated 8th May 2014, this tribunal has directed the Secretary Land and Land Reforms Department, Government of West Bengal, to conclude the proceeding initiated under section 6(3) of the said act, giving an opportunity of being heard to the petitioner in accordance with law. The present petitioner also filed a contempt application being number such and such, alleging non-compliance and willful violation of the order dated such and such, not necessary. Next paragraph. It is submitted by the petitioner of these present ways that the suit land is guided by the West Bengal Non-Agricultural Tenancy Act and is some Khotians of Mauja Bali. The status Dakulikar is noted as referred to page such and such, and therefore it cannot come under the provision of 6(3) of the West Bengal Estate Acquisition Act. Apart from that, it is also alternatively submitted and pleaded that the subject lands were purchased during the period from 1957 to 62, well after the cardinal date of the vesting of the subject land under the provisions of the West Bengal Estate Acquisition Act with effect from 14 April 1956. And there did not exist any mill, factory or workshop or karkhana on the subject land at the material date of vesting. Moreover, most of the plots of the subject land were classified as karkhana, but not classified as karkhana or mill, suggesting that there exists karkhana or mill. Instead, almost all plots were classified as bastu or such and such. On plain reading of some documents on record, as relevant therefrom, the status of the present applicant, which is represented by the Constituent Attorney Mr. Jalal Parikh, may be briefly stated. Grand Smithy Work is a registered partnership firm which was incorporated in the year 1941. By the certificate of incorporation bearing number such and such, and registered under the Director of Factories under the Factories Act 1948. The said firm was first started by late Balchandra Agarwal, and after his demise, his son Yudhishthir Agarwal and others formed a partnership business. The said firm had his office, godown and factories at number 1 Girish Ghosh Road, Belur, Howrah, and also at 5 Grantang Road. By combined operation of section 4 and 5, read with section 49 and section 52 of the West Bengal Acquisition Act, all the estates and rights of intermediaries in the estates and of riots under rights stood vested in the state with effect from 15th April 1955. As the case may be, free from encumbrances. Likewise, the subject land of an area of such and such was also vested in the state. However, Grand Smithy was allowed to retain the subject land for the purpose of mill, factory or workshop under section 615, read with section such and such and such. Now, kindly pause here for a moment. What is this? This is the finding of the court.
It is submitted by the.
I cannot submit this. This is against me.
Okay.
My lord, kindly correct me if I am wrong.
It has given
First
the
correct
answer.
is my contention. For the timing I take, this is the contention of the state. Then it is submitted by the instant or it is an observation of the court. This is the law has been quoted, not related to the facts of this case. It is submitted by the state applicant that an application dated 13 was filed by the GSW to authorize concern with prayer to delete the noting made on the finally published record of right to the effect that subject land is allowed to be retained by GSU under section 6(3) of the said act. But nothing was done. And this is, we asked for deletion of this. Language is, we asked for deletion of that comment. But nothing has been done until an application being OA number such and such was filed before the Honorable Tribunal, seeking redress and relief by way of concluding the proceedings in accordance with law. Accordingly, the Honorable Tribunal was pleased to direct the Secretary Land and Land Reforms Department by an order dated such and such to conclude the proceeding under section 6(3) of the said act already initiated by him in respect of subject land allowed to be retained by the GSW under section 6(3) of the act, giving the petitioner an opportunity of being heard. At last, a contempt application was filed against the state respondents alleging willful violation. The ASC and LRC Land and Land Reform Department concluded the said proceeding after giving the petitioner an opportunity of being heard, and then passed an order dated 20th March 2015 for resumption of the subject land measuring more than 40606 acre, as JW has failed to use or ceases to use the subject land for the purpose for which the retention of the same was earlier allowed under the provisions of the 6.3. But JW has filed OA number such and such with a prayer to set aside the impugned order and such and such, such and such. In pursuance of the resumption order passed by the ASC, the as communicated to the DM and Collector Howrah, grantsmithy works and other by the Assistant Secretary Land Department was initiated by the Subdivisional Land and Land Reforms Officer Howrah Sodor in 2015 for the purpose of formal resumption of the subject land, fixing a date on 29th April 2015 at 10:30 am upon service of prior notice, it is such and such, upon Grantsmithy works at Girish Ghosh Road, Belur, Howrah. On behalf of the state government of such and such, or the affidavit opposition filed by the state respondent and also at page 71 and 72. Two miscase being number 2115 for subject land of Bali Mauja and miscase number 22 for subject land at Barakpur Mauja under section 51(1)(f) of West Bengal Land Reforms Act were initiated by the BLLRO and Prescribe Authority Bali Jogacha Howrah for necessary correction in the record of right pursuant to the order dated 2015. During hearing at length, the advocate appearing for the applicant in the instant ways made the following submission. It is submitted that the Grantsmithy work is a registered partnership firm. It is contended that in the finally published record of right and pertaining to the subject land are described as the Holkar and the RS record it is described as Akrisi Poja, thereby clearly suggesting that the plots of subject land are governed under the provisions of the West Bengal Non-Agriculture Tenancy Act. Reliance is placed upon the judgment passed by the such and such, such and such. There is or was no scope to bring such plots of lands within the ambit of the West Bengal Exchange Act and allow retention of such plots of land under section 6.3 of the land, as there did not exist any mill, factory or workshop on the subject land on the date of vesting, and moreover, the said plot of subject land were recorded and were classified as such and such, such and such. It is alleged that the state respondent failed to initiate proceeding under section 6.3 of the said act against the vendor of the applicant, and therefore the original rights were not allowed to retain lands under section 6.3 of the said act. Any subsequent noting under section 6.3 of the Land Act cannot sustain in law, and therefore the impugned noting regarding retention of the subject land under section 6.3 is liable to be deleted. Moreover, section 3 capital A was inserted in the West Bengal Land Reforms Act by way of amendment with effect from 9 September 1980, whereby all lands held by the non-agricultural tenants like the Holkar Poja, such and such, the provisions of vesting and non-agricultural tenants are treated as rights, being entitled to retain such land together with other lands, if any, not exceeding the ceiling area as provided in the section 14M of the West Bengal Land Reforms Act with effect from 9 September 1980. The vendors of the present applicant were governed by the section 3A of the West Bengal Land Reforms Act. Reliance is placed upon judgment reported in such and such. The instant applicant for the first time came to know from the letter dated 2015 of the Assistant Secretary Land Reforms Department that Grantsmithy was allowed to retain land across the subject land under the provisions of 6.3 of the said act in the year 1963, and the said order of retention was issued behind the back of the applicant without giving an opportunity of being heard and in violation of the principle of natural justice. Relying on the judgment of the Honorable Apex Court in the matter of the state of West Bengal versus Ratnagiri was relied upon, it was contended by the learned advocate that there was no mill, factory or workshop on the subject land on the cardinal date of vesting, and therefore subject lands were automatically allowed to be retained by the original rights of vendors of the applicant under section 6(1)(a) of the West Bengal Exchange Act. There was no necessity of passing any retention order by the state government under section 6.3 of this act for the purpose of mill, factory or workshop. It is also submitted that no resumption is lawfully taking into account the subsequent events, that the closure of the mill or factory, and therefore the order there such and such is not sustainable in the eye of law. Reliance was placed, my lord, the judgment was relied upon. Now, my lord, the state government's paragraph 9. During hearing at length, the landed government representative appearing for the state respondents in those ways made the following submission. While referring to section 2(8) of the West Bengal Non-Agricultural Tenancy Act, the learned GR submitted that this act its root in the Transfer of Property Act. In the same way, the West Bengal Estate Acquisition Act has got its root in the Bengal Tenancy Act, and it is manifestly clear from section 2P of the West Bengal Estate Acquisition Act, which speaks for such inter-se relation between West Bengal Estate Acquisition Act with the BT Act. No doubt about that. Emanating from there, Bengal Tenancy Act.
Yes.
It is submitted to the Alas Khoti number such and such, pertaining to the subject land, which are brought on record by your supplementary affidavit. All of them bear the status of Rayat Sitiban or Rayat Dakolikar, such and such, was absolutely governed by the West Bengal Tenancy Act and subsequently by the West Bengal Estate Acquisition Act. So the lands recorded in these RS Khotians cannot be governed by the West Bengal Non-Agricultural Tenancy Act. Absolutely wrong. Likewise, the subject land comprising RS Khotian number 3610 Mouja Bali bears the status of Dakholkar. Two of the subject plots of such and such were recorded in this Khotian. Here RS Khotian is Niskor. From the definition of non-agricultural tenant as laid down in section 2(5) of the West Bengal Non-Agricultural Tenancy Act, it appears that a non-agricultural tenant was always liable to pay rent to her landlord, unless there is a special contract for exemption of rent. In the instant case, there was no evidence of any such special contract than may I pose a question to myself. Who is to prove that? State has to prove that this was not by a special contract this was allowed to. I am not. Then
the land was Niskor.
Niskor. From
no rent was asked in respect of that land.
My lord?
No rent was asked to be paid.
Paid on that land.
Rent free.
Rent free land. And that is one only. Among these, it is one.
Okay, next.
The transferor of the said deed was ascribed the subject land of that deed as ancestral rent-free property. At page number 34 of the supplementary affidavit, suggesting thereby the tenant had got no special contract for rent exemption between the landlord and tenant under the West Bengal Tenancy Act. Rather, it had got a legacy of Niskor status under the BT Act. Apart from that, from first page of the said deed, it is evident that the transfer was made under section 12 of the Bengal Tenancy Act 1885, which deals with the voluntary transfer of permanent tenure. The term permanent tenure has been defined in section 2(9) of the Bengal Tenancy Act, which means a tenure which is heritable and which is not held for a limited time. Under section 4(1) of the BT Act, tenure holder was being included as one of the classes of tenants. So it is submitted that the term tenure denotes only Moddhasatva Adhikari, which is nothing but an intermediary coming within the purview of section 2(1) of the West Bengal Excise Agreement Act. The claim of the applicant that the subject land is governed by the West Bengal Non-Agricultural Tenancy Act merely for the reason that there was nothing of noting of Dakholkar in the RS record of right in respect of tenant or original right is not at all sustainable in law. My lord has to decide. All Dakholkars noted in the aforesaid RS Khotian, of course, illustrative and not exhaustive, are not necessarily guided by West Bengal Non-Agricultural Tenancy Act. It is submitted that nothing noting of Dakholkar or Okrisi Poja cannot be a bar to proceed with the proceeding under section 6(3) of the Estate Act, even if the land is guided by the West Bengal Non-Agricultural Tenancy Act, because evidently there is the statutory scope as envisaged in section 5(1)(c) of the Estate Acquisition Act, which starts with the non-obstantly clause subject to provision of subsection 3 of section 6. However, in the instant subject land was not guided by the West Bengal Non-Agricultural Tenancy Act, and instead it was actually guided by the Bengal Tenancy Act, as discussed herein above with documentary evidence. And therefore, all the provisions of section 4, 5, 49, 52 on section 6 of the West Bengal Excise Acquisition Act are applicable to the subject land of 4605 acres. So the judgment passed in the matter of Tostidas Mollik is not applicable to the instant case. It is submitted that a comprehensive report based on reconstruction survey was prepared by the Assistant Settlement Officer and Charge Officer, however, Howrah, under the provisions of section 6(3) of the said act, by of initiating on such 60, a proceeding being number 92 upon service of notice such and such upon Grant Smithy works, and after giving an opportunity of being heard to its authorized representative to 62 and file against such and such the state government. The state government, having been satisfied with a comprehensive reconnaissance and survey report regarding existence of mill, factory, workshop run by GSU firm, and was of the considered opinion to allow retention of subject land of such and such for the purpose of running of the mill, factory, or workshop under the provisions of section 6(3) of the act. Therefore, it is quite evident that the Grant Smithy works was existing, its mill, factory, or workshop were operational on the subject land and by Yudhishthir Agarwal on the cardinal date. This is the conclusion. Not from the record of right. Some survey
It is submitted on behalf of the state.
that has been accepted. If this is not accepted, I am through. Only point is on that cardinal day whether mill factory was in existence. Our specific case is in 1960. After 1962, Grant Smithy started operation his factory in the suit land. Then it is submitted that the Honorable Supreme Court inter alia in paragraph 15 of the judgment reported in 2001 has been pleased to emphasize on necessity and importance of field study, reconnaissance and survey report for formation of opinion based on materials by the authority. It is also submitted by the learned GR that the in charge director of factories had sent a report to the ADA builder such and such filed by the state government, and he has quoted the following report and brought the same to the attention and consideration of such bench. Grant Smithy, the reference to the above, we are furnishing the following information that are available. Grant Smithy registration number, license number. It was there. The company was registered in 1941. No dispute about that. That we are not denying that. The aforesaid factories were registered under license issued in compliance of the provisions of the relevant rules of West Bengal factories such and such prescribed under section 66 of the Factories Act 1948. Well, can you pause here for a moment? Our purchase in 1957. It starting point is 57. How I can run a factory on that land prior to that? I'm asking the question to myself. Whatever survey you do, I am in the possession of this land in 1957, the admitted fact. And prior to that, somebody else was there and there was no noting of any factory. I started operation my factory post 1962.
Okay, then
how it can be related back to that date on 55?
yes.
Referring to that quoted report, the learned GR has claimed that the said factories evidently existed on the subject land well before the cardinal date of vesting on 14 May. My lord, this is the finding and content to extend thereafter. A composite sketch map of the Barakpur Mauja and Bali Mauja submitted and explained during the oral submission before this bench, claiming that the same patently illustrates and suggests how the subject plots were comprised in factory and workshop as on the date of vesting. Therefore, the order dated 21st October 63 passed by the state government allowing retention of subject land for the purpose of running field, factory, or workshop that existed on the subject land on the cardinal date of vesting in accordance with law, taking into account the reconnaissance of survey report, file study report, field study report, and also giving an opportunity of being heard to the authorized representative of the Grant Smithy. The alleged claim, the applicant, that it was not at all aware of the impugned retention of order before being informed on 2015 by the assistant registrar is afterthought and absolutely not true. It is submitted that having considered the submission made by the instant applicant and having gone through the materials documents On record, this Honorable Tribunal was pleased to direct the Secretary to the Government of West Bengal to conclude the 60 proceedings already initiated. The applicant firm accepted that order, did not file any WBLRT challenging the said order in the Honorable High Court, and rather it filed contempt application being number such and such. It is not governed by the provision of the West Bengal State Regulation Act. In section 6(1)(a) to E to the said act, for retention of land by a tenant, the sealing excess agricultural and horticultural land of any other specified category of land have been clearly specified. Whereas, in respect of retention of land for the purpose of tea garden under section 6(1)(f) and for retention of land for the purpose of mill, factory or workshop under section 6(1)(g) of the Act, it is clearly laid down in section 60 of the Act, in the case of land comprised in a tea garden, mill, factory or workshop, the intermediary or where the land is held under a lease, the lessee shall be entitled to retain only so much of land as in the opinion of the state government is required for the tea garden, mill, factory or workshop, as the case may be, and a person holding in under a lease shall for the purpose of assessment of the compensation be deemed to be an intermediary. It is therefore submitted that the very use of the words so much of such land not only denotes the legislative intention of allowing so much land which is required for running mill, factory or workshop, not limited to any specific sealing areas, and irrespective of land, any classification of description as may be recorded is record of right. Madam, kindly pause there for a moment. Now,
Yes.
a land, factory is running on a land. A person is the owner of the land. So, every owner have a ceiling for retention of his land. Is it the intention of the legislature that for the purpose of running a mill, of individual who is the owner has no ceiling? So today, my lord, can you visualize one thing? Today I have 2 katas of land running a chakka, atta chakki. It is also factory. 2 katas of land running an atta chakki. Tomorrow it closed. Land will be resumed by the state government. Man, kindly think. No other land in West Bengal. I have only 2 katas of land. I am running an atta chakki in the land. There is a factory, and due to some reason or other, atta chakki closed. Even if I have 2 katas of land only, it will be resumed by the government. Simple answer is, my lord, no.
Yes, you have stated that the land below the civil limit,
That is the
even
sine
if
qua non.
used as a mill and factory, cannot be vested in earlier date.
That is the sine qua non. Unless it is
And on
beyond ceiling.
earlier date, I stated that the legislature classified the land according to the mode of use.
User.
Mode of use. Okay. Agricultural land, non-agricultural land, in such a way. Now, if the land on the date of vesting is shown to have been being used as mill and factory, then what will happen?
Then there is no ceiling.
What section 4 and 5 says?
My lord, 2 things.
What section 4 and 5?
My lord, two things people also kindly, my lord, giving a thought, but it is my lord, easy for me to try to answer. One is that a person is running a factory. A person is running a factory. So there is no ceiling. Then what is to be allowed to be retained? Allowed to be retained means, and to be retained, 2 concept is there. One is allowed to be retained and one is retained land. Retained land means up to the ceiling. By operation of law, you can retain. And allowed to retain means, necessarily means, in English language, my lord, that you are unable to retain by operation of law, so you are allowed to retain for a specific purpose. These 2 concepts, my lord, if your lordship apply in the Estate Acquisition Act, one is you can retain land because I am below ceiling, and another is beyond ceiling. That's why you are allowed to retain. Unless there is ceiling, my lord, there cannot be any concept of allowed to retain. I given a very simple example. That is not the interest of why this legislature to equal distribution of land. For this purpose, this act was promulgated. So kindly again, I repeat, my lord, kindly visualize if person has 2 cutters of land and running a factory. Closed. Land will be vested to the state. He'll be landless.
If a person having a land below ceiling line,
I'm given a 2 cutters of land.
below ceiling, if not retain the land under section 52, whether his land will be vested or not.
I am trying to give an illustration. On 15th April 1955, a person having only 2 cutters of land in West Bengal was running a small factory. Like in Howrah, there are sort of small factories were there. On the date of cardinal date, he was running a factory. On the following month or following year, 1957, his factory closed. He is being proper. His heirs will not have the land.
Yes.
But am I clear what I intend to
Yes,
submit?
yes, we have understood.
This is my lord.
But if
what
a person purchased a vested land
No, that is separate.
and started running factory later on and claiming that no, on the date of vesting there was no factory,
No.
then what will
If it is vested under any other act, that is vested all time to come. That is vested all time to come. On the date of vesting, if there is no factory, then 60 will apply. If he has excess land,
Yes, yes, all talking about hypothetical question, let us come.
here it is necessary.
Go into
I
the.
am not hypothetical at all because it is necessary because we have to see, my lord, on the date of vesting whether there is a running factory or not. And and excess land.
You have submitted that there was no running factory on the cardinal date of vesting.
And
date of vesting. Yes, in your case.
Yes. And coupled with that, my vendors which was on that date, they don't have any land in excess.
Excess land, yes.
That's all.
Yes, you
That's
have
why
stated. We have noted the same.
Yes. That's why
no,
I've given,
proceed.
That's why I've given the illustration.
Yes, proceed.
What will happen? In the light of discussion and submission of the facts and law points, it is submitted that the ratio of the judgment relied upon by the applicant in the matter of Saregama, such and such, all judgments was considered are not applicable in this case. So one line. Legislative intention to incorporate such provision of revising the order passed under the main part of section 60 of the West Bengal Act is clearly explained through the amendment of West Bengal Exceptional Act, where the explanation 2 with effect from validation from the date of coming into force of the principal act was previous that. For the removal of doubt, it is hereby declared that the expression revise any order mentioned in the proviso to the subsection shall notwithstanding anything contained in any other law for the time being in force, or in any agreement or any decree, judgment, decision, award of any court, tribunal or others authority, include revision of any order of such and such, retention of so many, if the intermediary or the lessee, as the case may be, fails to use or ceases to use the whole or any part of the land for the purpose of which it was written, that is for written. Written.
Yes.
Or factory by him so as to resume such land as being surplus. But I am not disputing the proposition. I am not disputing the proposition. Because I say the ingredients of vesting, so far my case is concerned, is not applicable. Yes. Then, therefore, the order dated 15 passed by the ACS formed illegally and necessarily and according with law. And an advocate for respondent number 5, Belu, Somajibi, such and such, they cannot say anything because they are the subsequent beneficiaries. Then the findings. Point number 1. Is the applicant's plea challenging the order of retention dated such and such passed by the state government, allowing Groundsmithy work for retention of 406 feet for the subject land for the purpose of running mill, factory, or workshop under the provision of 60 day due succession of the owner are maintainable? my challenge was maintainable or not, that was the question. Is the impugned order passed by the ACS land reforms for resumption of such a land, subject land allowed to such and such? Now the Malon answer. Point number 1. These are 2 points. Answer. Having carefully considered the submission made by contesting parties and having gone through the documents on record, it clearly reveals that the state government duly examined and survey report regarding status and operation of mills, factories or workshop on the subject land, which was prepared by the Assistant Statement Officer such and such, Howrah, by way of initiating on 60, a proceeding being number 92 upon service of notice of Dan Smithy works and after giving an opportunity of being heard, so it is authorized representative. The consensus and survey report was duly prepared after considering representations and the submission made by the authorized representative by the firm. The Honorable Apex Court in Tandon Brothers case intelligently observed on necessity and the importance of field and study, like reconciliation survey report for formation of opinion. Ratio of the state judgment is applicable to this case and therefore it is followed and relied upon. The state government having been satisfied with the comprehensive reconciliation survey on the existing status of mill, factories, workshop operating on the subject land and was of the considered opinion to allow detention subject to such and such purpose of such and such. Therefore, the plea taken by the applicant found that it was not aware of the detention order such and such. It is significant to note that long after more than 50 years, the applicant firm was taken diametrically of different and view vis-a-vis the impugned detention order, and it was intended to challenge the said detention order, which is at this stage barred by the Provisions of Limitation Act, as laid down in Section 55A of the West Bengal Legislative Act, and which was never challenged by it before any higher forum, judicial forum. It is alleged that the state government had acted unlawfully in passing the impugned detention order, as the subject land ought to have been guided by the provisions of the West Bengal Non-Nuclear Tenancy Act, not by the provisions of West Bengal Legislation Act. But it appears that it has also moved this tribunal by of filing a contempt application, same repetition. The instant applicant did not deem to proper to challenge that proceeding initiated under Section 6(3) of the Act. On the contrary, it urged this tribunal to pass direction of the state government to conclude the proceeding initiated under Section 6(3). The validity of the illegality of the order of 63 cannot be challenged by the applicant at this stage after more than 50 years. Well, the answer is it was never communicated to us. It was never communicated to us. When we came to learn in 2015, we challenged that. Without challenging the same before the appropriate judicial forum. The applicant has also taken another plea that this firm does not come under the purview of 6(3), as the total area of subject land is within the ceiling area, as prescribed under Section 6(1)(e) of the West Bengal Legislation Act. For better understanding of the extent of law in respect of retention of the land, such and such, in the case of land comparison tree garden, that I have already read. No classification of land like agricultural and horticulture, and also no ceiling areas whatsoever are mentioned in respect of retention of such land. It will not be out of place to mention that paragraph 11 of the judgment dated 24 February 2009 passed by the Honorable Apex Court in State of West Bengal Ratnagiri is relevant in this case. It may be quoted. Perusal of Section 6 of the 1953 Act disclosed that there is difference between subclause A to E of Section 6(1) on the one hand and subclause F and G of Section 6(1) on the other. While in the case of land which can be retained under subsection A to E of Section 6(1), the retention is automatic from the date of vesting, and no order of any authority need to be passed for the purpose. In the case of subsection F and G of Section 6(1), the retention after the vesting is not automatic, but it is only when the state government passed an order under Section 6(3) of the 53 Act. In other words, after the date of vesting, the lands mentioned in subclause F and G of 6(1) cannot be retained by the intermediary unless and until an order is passed by the state government under Section 6(3). In the instance case, the state's retention order was passed by the state government in 1963. The applicant firm claims that there did not exist any mill, factory or workshop on the subject land on the cardinal date of vesting of the subject land. Being deemed intermediary under the provisions of West Bengal Legislation Act, and the subject lands are classified as Bastu, Bagan, Danga, such and such. But some documents on record suggest that groundsmithy works and its mill, factory, or workshop evidently existed and kept on running on the operating date. My lord, kindly, my lord, I failed to find except this so-called survey report any document to show that on that date the mill and factory was in running condition. Land comprehensive vesting of subject lands under the provision of the West Land. Comprehensive factory mills, workshop, and such. This farm filed the certificate of such and such and registered under the director of factories. The said farm was first started by late Chandra Agarwal. After his demise, his sons Yudhishthir Agarwal and others formed a partnership business. The said farm was a such and such. That GR has brought to notice of this bench a report sent by such and such, director of factories, Howrah, in reply to his letter to such and such, and was submitted that the report quoted below clearly corroborates the factum of GSW and its mill or factory. It's the same thing. That everything is repeated, but so that's why it was so bulk. Having considered the report, the documents on record, this bench is satisfied reason to believe that there existed mill. We are all convinced and satisfied to accept the argument advanced by the learned GR to the effect that while referring to section 2(8) of the West Bengal Non-Technical Tenancy Act, it transferred that this act had not root in the transfer of property acts. It's same thing, my lord, it is the same thing, repetition. Well, we will find that it is just repetition. Next page is also repetition. Then, my lord, kindly come to 240. The claim of the applicant that the subject land is governed by the Non-Technical Tenancy Act merely for the reason that there was noting of the whole card in the remark column of the record of right in respect of tenant of original right is not at all sustainable in law. All the occurrences noted in the aforesaid R.S. Kotian Now, my lord, then the court is saying that these documents, those are illustrative and not exhaustive and not necessarily guided by a mill, factory, or workshop may comprise and normally comprised land on different nature, description and classification. This they have said, my lord. Now, my lord, give me 1 minute time. How the record of right prepares? Record of right prepares, my lord knows it, can you allow me to say? The department people will go to the local, inspect the land, see who is in possession, what is the nature of possession, this is physical verification. How they did in the office, that is separate thing. But the presumption is that they will go to the local, observe the land, find out who is their dakhulkar, and then put the remarks. But they went there, presumption is they went there, seen that there is pond, factory, water bodies, pathways, everything, excepting the my lord mill on that date. And court is finding that it is illustrative. It is normally on the water bodies, factories are, can you see the next? Works of compression normally comprise land of different nature, description and classification, and there may be structures, sheds, buildings, and quarters for marginal and other employees, workers, water bodies, fallow land, pathways, and for other related issues of effective running of a mill or factory. Therefore, the claim and the proposition of applicant that the subject land is gone, recurrent and is cannot sustainable in law. Record of right presumption, I am not saying in the presumption of title. It is a presumptive value about the nature of the land and possession. Rebuttable, but till such is not rebutted, it is possession and the nature of land is, well, your lordship has to give cognizance of that. Now, so far as this land is concerned, if the record of right says other things, and presumption says it is mill factory. But I am astonished. May I take one thing? In the concluding portion, this illustrative or exhaustive, and I am unable to understand. I am very clear to understand. Because of the fact, my lord, we all know how the record of rights are prepared. Factually, officer went there and found there are this type of character of the
Khanapuri, Bhujarhat, and such and such, many other stages.
There has to be
Draft publication.
Has to be on spot.
Thereafter,
so far we are concerned, we are to the person has to be on spot for recording in the record of right.
But it was finally published.
Ultimately, finally published.
In and around 50-55 in most of the district of our state.
Done that part.
In some of the 60. But this in the RS record of right, it was recorded the section 6.3 applies.
When?
When you have challenged it?
63.
When?
It was in 63. Can you see the date?
Maybe 63.
So 63.
So it has been incorporated in 63 according to you.
Not according to me, according to the
okay,
insertion.
No, when it has been incorporated in RS or ROR, that is not on the record.
Yes, that is on record. Well, kindly once come. Date is given there. When it was recorded.
That is 63. 63 order was 63.
Right.
So after 63. But when you have challenged.
I have challenged when it was known to me, 2015. Thereafter it was not served upon me.
Final publication of the
there was a proceeding initiated. I participated in the proceeding.
Yes.
Not served. Final order has not been served. It should be from the date of service of notice, the order.
63 hearing concluded and order was served in
63 insertion thereafter.
2015.
63 insertion was there.
After 55 years, order was served.
I may not be clear. In 63 insertion was there in the record of right.
Yes.
My first submission is that insertion in 63 cannot be there because But kindly once look to that record of right page.
Yes.
The nature of land character given as A, B, C, D, which is not coming under the purview of 63. 63 itself on the face of it is bad. if I record, my lord, a dalan, nature is given as a dalan in the record of right. And I insert, the state government insert is 63. On the face of it, it should go. So I repeat, my lord, for the purpose of insertion of 63, there should be a mill and factory running on that date. Yes. And this is the finding that those recorded in the arrest record, which the person went to the local, ascertain it, then recorded, that has no value. Presumptive value is there that there may be a factory.
So why there was a survey? Why our Supreme Court failed the survey?
Survey has to be made.
So as and when it will be on table, it will be placed RS record of rights. Oh, it is Vastu. So there cannot be any factory.
Right.
Since Vastu has been recorded.
That's the correct.
And hence the Supreme Court failed. No. Despite having recording of Vastu, maybe the land where mill is going on.
How is
mill is operating.
But how is to be ascertained? I'm asking
And
the
hence
question
was
to
a
myself.
survey.
Here, my lord, they proceeded on the only on the basis that this GSW has a license in 41. There was no element of running of the factory. Only the 1941, the GSW was a license of factory, not the vendor who was there on that date.
Okay. Yes.
Petitioner before my lord is a running registered factory owner in 41, not running factory on that land.
Yes.
My vendor had no factory. I had a registered office there. That necessarily not mean I'm running a factory there. Yes. My lord, so this is the, my lord, how this cannot be, my lord, the 240 F, paragraph F. And when my lord will be looking at to this survey report, my lord will see how they gather this. Now, point number 2.
Yes.
The present applicant had also filed way before this tribunal with prayer for setting aside the notice dated such and such issued by the subdivisional land and anti officer in connection with the conducting recension survey in respect of same land allowed to be retained under section 6(3) of the act. Oh, one thing, my lord, this survey report was next served upon us.
When survey was made?
This reconciliation survey, that is the basis of this order. And the tribunal also relied on that. To conduct the proceeding initial section C, giving an opportunity of being heard to the petitioner in accordance with law. The present petitioner had also filed a contempt appeal. Same thing, my lord. This is repetition. This how this judgment has been. Same thing.
Full point.
It is established fact that the instant applicant was given an opportunity of being heard before passing the impugned resumption order passed by the such and such in accordance with the law. Therefore, the said order of resumption passed by such and such on the state government does not suffer from any legal infirmity or lack of jurisdiction. Judgments of the Honorable Court and the Honorable Apex Court as cited and relied by the applicant have not much helped to improve and the applicant's submission and arguments on fact and law points and the ratio of judgment. So one line, not judgments are not considered. What is the ratio decided, not said. One line, it is not applicable.
From whom you purchase?
I have purchased from I just a minute, I'm giving. You will also find the name in the record of right.
The property actually was of Roy. Roy was the
Yes, my lord.
uh,
63,
intermediary.
63 kindly come. There are so many dates. We have annexed. 63 is the first one. পদ্মলোচন কয়াল and নাবালক তারাপদ কয়াল.
Of page 185.
85.
Record of rights.
Page 185.
85, yes, some Das or Satansa. They are the intermediary.
Yes.
First.
Top.
Top. You come to top.
Yes.
নিষ্কর 20 বছরের ঊর্ধ্বে বিরুদ্ধ দখল প্রমাণ সূত্রে।
But they are
It is in respect of Satansa.
Kindly come to the
Now come to even now who is the দখলকার?
Dakolkar is
দখলকার was Narendranath Konar.
maybe his years.
On such and such their share. Then Dakolkar, then the present remark was inserted.
If he is
Inserted in the year 1963.
If he is Dakolkar, his right is there.
Yes, Dakolkar, but they are the So Konar was the Dakolkar. Now
Immediately I cannot
subsequently
I don't know which land is this.
187. 187 same plot.
No, different plots. I have purchased
187.
I have purchased by
Now
4 or 5.
187 is yes. Amitabh Rai, Tarapada Saab.
If you Lordship want, I can
Now
make it reconciled and
they are the intermediary. Now Dakolkar is the Bhupendranath Rai.
yes.
Such and such.
Rayat Sithiban.
অত সন হইতে যুধিষ্ঠির লাল
Then how about
Agarwal.
this insertion can come here?
Yudhishthir Lal Agarwal and
Yudhishthir Agarwal is
Agarwal.
Your vendor.
My vendor.
1364 সন হইতে যুধিষ্ঠির লাল তার মানে 1957.
Yes.
The property 1957 Yudhishthir Lal. Yes. Now he became the Rayati Sthitivan. Okay. If we say that he is a Rayat under section 4 of Land Reforms Act. Now you purchase from Yudhishthir Lal.
Yudhishthir is my client.
Yudhishthir is the
Yes, of Gansmiti. Yes. We are Yudhishthir Lal.
Yudhishthir is the, we are trying to whether the earlier vendor is partner of the company or not.
No. No.
Yes.
Those are Agarwal.
So, Yudhishthir Lal.
Those are Agarwal. We are Agarwal. They are Koyala, Bengali.
Oh, okay. Well, maybe then.
Not partner.
Yes. So Yudhishthir's name was recorded in 1957.
My lord, I cannot take an answer from the court, but one thing is I am prompted to say, my lord, in this record of right, whatever it is, how, my lord, this Bhumi Rajaswa insertion can come? This insertion can come. How? I am asking the question to myself.
Later on, it is as per the order dated such and such.
How this order can be passed on a document? The land is, my lord, Raya Sithiban, and description of the land is, my lord, Dalan.
You never challenge that order.
Okay. It
Now
was
you
never
challenge that. Now whether your challenge is justified or not to find out. So 1957, from 1957, Yudhishthir became the Raya Sithiban as per the record of rights, RS. Then, in respect of one Vastu Dalan, then one Gangendranath Bosu, Ganendranath Bosu is permanent.
If Lordship want, I will reconcile and give a chart. So which record of right?
From whom you purchased?
Yudhishthira Agarwal purchased from the Koyal sometime, Krishnamon Ghoshal, I find someone Ghoshal is there. One Mr. Dhol is there. If that is
In
requirement,
2008, one miscase was started. In 2008, then Gant Smith work, you come to page 193. One miscase was started, 1101 of 2008.
193.
Hmm.
193 is record of right.
Record of right, but
Okrisi Puja.
okay, land, you have to see at the upper portion. The land was included in Khotian number 1. That means vested.
That is the
And
question.
Poshimbango's Pokke collector.
That
means already vested.
right.
Maybe he is Okesi Puja. Land is vested. Khotian number 1.
But if he is Okrisi Puja, he will be right.
Then it will.
If he is Okrisi Puja on that date, he became right.
Khotian number 1 is collector's.
Right.
You know very well. Land has been included. Khotian number 1, now 193.
I've seen that. Paschim Banga
That
Sarkarer
the
Pokke
land has been
collector.
vested. Maybe what is your Khoti?
This is Paschim Banga Sarkar. So it is Hotel number 1. But the Okrisi Puja is there.
Yes. You conclude.
Oh. Well, my lord's query, paragraph 32. Yes, my lord,
Order to be, or to back cutter to be.
kindly
Yes.
kindly come to paragraph 32.
32 of?
Paragraph
Oh.
of the petition. 193.
Yes. Yes, same thing. 3 points.
Not
you have.
points. Not points. It is further submitted. Kindly last 4 lines from the bottom. It is further submitted that no information of the order passed by of any of the authorities at relevant time was ever communicated to the petitioner. Last as there is no scope of the petitioner to challenge the same at that relevant point of time. The petitioner only came to know of the aforesaid order in course of hearing of the proceeding before the respondent number 2 held on 2015, and upon coming to know of the petitioner challenged the said order of such and such. It is not served upon us ever. It was not known to us. Oh, yes, maybe possible. Now, let me, one thing I was inquiring from my friend, he is correctly pointed out. My lord was saying that this why is one Khotian number 1? There was a Karkhana. One Karkhana was, Kali turned over the 194. 194. 193, my lord Justice Chatterjee has pointed out. This is number 1 Khotian. My lord will find Vastu and slight portion is Karkhana.
Where page?
194, my lord. 19018.
A Karkhana has been recorded.
Yes. Small portion is Vastu is there, 1 Karkhana, another thing, and Kua. 3 items are there, very small portion. Probably that is for the reason it was number 1 Khotian. Not the entirety. Probably I try to satisfy my lord's query. It is also, it is, I'm frankly speaking, my lord, it don't strike me before your lordship pointed it out to me. I was shocked. How is number 1 Khotian I purchased? thereafter I find out that this is, and I marked that.
Bastu also, Bastu.
And the Bastu 19018.
Or Tinkhana Ghor, Bastu, Dukhana Ghor, Sachansaj, all. It is Gan Mistri works. All under Khotian number 1.
Yes.
That means all vested. All were vested.
Which one?
194.
Grand Smithy Works is Bastu.
Maybe.
Bastu will be vested.
It has been shown.
I have nothing
Khotian
to
number
say.
1.
I have nothing to
It
say.
is the plot number.
That's the challenge. Bastu, my lord, we have their office there in the Bastu. Factory we started, I repeat, in after 1962. And this one small portion Karkhana for this, maybe it may go to Khotian 1.
Yes, yes.
But not the entirety.
Yes, that's all.
Now, my lord, now I have to cite the judgments for your lordship. $74 weekly notes. Then
written argument.
no, this is the copy of the judgment. We have also prepared it in short notes for your lordship. But short notes, don't scold me. Short notes is running page 18. But kindly turn 74 Calcutta weekly note. কোথায় আছে সেটা দেখাবো কি করে আমরা 36
Yes.
kindly come to I will travel a lot to the entire judgment কি দেবো জাজমেন্টে কপি দিতে হবে রিপোর্টের জাজমেন্টে মারবো এমন না not for my
Yes. Non-agriculture tenant cannot come.
No, not for that purpose.
Within section
notes, I am citing that record of right on the date of vesting has to be looked into. Can you come to paragraph 4? Paragraph 2. This need again.
Yes.
Yeah, we Page 36. That is the head note. Those on those days, head notes are prepared by the person not like me. So head notes will suffice. Justice Ojoy, late Justice Ojoy Rather used to say, paragraph 2. The record, therefore, must have reference to the state of things as it exists at the said date of vesting. So Justice P.N. Mukherjee and Justice Bakshi, my lord, can you see the strength?
Yes.
But let us seen that which was made to submit that on date of vesting, what was the situation there? How is to be gathered? Presumptive value is the record of right. On that it has recorded. And if it's to override that presumptive value by this survey, then it has to be an overriding effect. Materials will be such to disbelieve the record of right. That report is not before us. It has not been served. And court proceeded on the basis that the committee's report is overriding the record of right. It says there is no fact.
Survey report was produced before the tribunal.
It as it appears, but not served
Appears
upon us.
from the record,
As it appears, but not served upon us.
from the order.
From the order
It appears that survey was looked into.
So, Mr. Kalyan, survey report was there. Must have been.
As it appears from the record. See,
We copy, I have this opposition.
No, not over in the judgment. Twice or thrice it has been referred to.
The
Yes, as a
reconnaissance, Lordship.
reconnaissance, sir.
Lordship.
Yes, Mr.
Yes, yes, next.
Malad. So this is Malad. This is only for this proposition. One is record of right should be at the date of vesting, and the record of right will depict the state of affairs on that date.
Yes,
Necessarily mean the record of right.
yes.
Now, my lord, next I will rely, my lord, 2015 8 Supreme Court cases 655. चलो ना 101. They got it. Page 100, the bunch, it is 101. Well, paragraph 40. Mr. Guptal under senior counsel rightly submitted that after coming into effect of the aforesaid act, no order was passed by the authority concerned against the respondent since the land held by it was well within the ceiling limit.
Paragraph 40.
40. 40.
1176. Page 116.
Page 670 or in the bunch, my lord.
Yes.
Yes.
So, my lord, if the land is not to be proved before the court that it was in excess of ceiling limit, it cannot be vested.
Yes, that's all. Okay. Other judgments are known. Ratnagiri.
My lord, 1967 Supreme Court 940.
Yes.
Kindly see.
Page 20.
Yes. But, kindly come to 940. Paragraph 9. Counsel, however, contend that the first respondent having merely the right to receive rent, it was an intermediary within the meaning of Act 1 of paragraph 9.
Yes.
Under that act, the interest of such an intermediary vested in the state on the extension of the Act of Chandanagar, and therefore the association had no locus standi to apply for transfer. This contention also cannot be accepted. For an intermediary, as defined in section 2(1)(I) of the Act, means a proprietor, tenure holder, under tenure holder, or any other intermediary above a right or a non-regular tenant, and in relation to mines and minerals, a lease or sublease, it is thus obvious that the first respondent, being itself a non-educational tenant, in respect of the entire land, including the land in dispute, it does not fall within this definition. Not being thus an intermediary, it is impossible to say that an interest in the land in dispute vested in the state or that therefore it was not entitled to apply under section 24. In my lord. Now, my lord, 2012 Calcutta 248 equivalent to my lord 2012 2 Calcutta High Court Note 572.
Yes.
That my lord will get at page 50 to 59. Now, kindly take travel to see paragraph 32 and 59.
Paragraph
32 and 59.
Yes. Page 54.
A 59.
না, না, সবাই পড়তে পারে।
32 অনেক পড়ে ফেলেছে 32 and 59
হ্যাঁ ওই জন্য মিলছে
ওইখান থেকেই তো পড়ে দিত
kindly come to page 58 of your lordship's bunch at paragraph 59.
49 আবার বলছি।
Prime page 58
58.
By way of illustration.
In a very recent judgment, yes, by way of illustration, the land with structures coming under clause 6.1b may be not necessary for our part. 59. In a very recent judgment, the Honorable Supreme Court in State of had observed that retention is automatic from the date of vesting and no order of any retention is a authority need to be passed for that purpose. In the case of clause F and G of section 6.1, the retention after the date of vesting is not automatic, but it is only within the state government passed an order under section 6.3 of the Act of 1953 Act. That is Ratnagiri. Has been quoted by your lordship's court. And this was travelled to Supreme Court and SLP was dismissed. Yes. But kindly take travel to see the next page. SLP was dismissed. That is on merit. Now, my lord, দিচ্ছি ওটা পরে এক সেকেন্ড 55টা কি আছে একটা এত কাগজ না গুলিয়ে গেছে But I have annexed those judgments which has also relied upon in the other judgment. The bunch was also given. But I am mentioning, my lord, 2009 4 Supreme Court cases 453. It is Ratnagiri.
Yes.
Paragraph 10. (2015) 8 Supreme Court cases 655. Paragraph 40.
2008.
2015 8.
Oh.
Supreme Court says 655. Para 40.
Yes.
And 2017 3 Supreme Calcutta High Court notes.
You are finalist.
97. Paragraph 48 to 66. And also keep a note, SLP dismissed.
কত কত বললেন
17
17 paras
97. Page 97. Paragraph 48 to 66.
Right. প্যারাস গুলোতে লেখা নার্স পাওয়ার দিয়েছে দেয়া
কোথায় লাগিয়েছিস
পেজ
Now, my lord, one judgment you will also get it. My colleague submission is SLP dismissed, review pending, all points was taken in another matter. Kindly come to page 62. The Attorney General appeared in this matter. Same point was taken. That the review is pending. The Supreme Court এখানে রিলাই ওইটা দিয়েছি এখন রিলাই করে just a minute madam. Now kindly come to page 66 paragraph 5 where my lord my contention has been recorded and ultimately accepted. An application for review cannot be an appeal in disguise. There is a world of difference between the error apparent on the face of the record and an erroneous decision. In this regard, he has relied upon the decision of Hutchinson 22/7 to argue that the review applicant's ground for review is not only misconceived but also redundant in the facts of the case. The mandamus appeal was preferred against the judgment and order of the learned single judge, which was delivered at a time when the proceedings under sections 14T was pending and was not yet disposed of. The division bench affirmed the finding of the learned single judge, and in spite of such finding, the state authorities willfully and deliberately disobeyed the order of the learned single judge, and for which the writ petitioners were compelled to file an application for contempt against the governing government officials. The appellant, namely the state of Bengal, never filed any application for taking note of subsequent events before the division bench, stating that after the disposal of the writ petition and before the date of hearing of the appeal, the 14T proceedings are presently suggested. Mr. Basu further submitted that when the very initiation of 14T proceeding was bad in law and without jurisdiction, any order or further order passed thereof is irrelevant or redundant. The self-same ground was agitated. This is the main thing. The self-same ground was agitated before the Honorable Supreme Court and was heard on merits in presence of learned advocate of the parties and was rejected after hearing. So the present application for review, being wholly unsustainable and meritless, is liable to be dismissed with cost. Because the same ground which was taken in the Supreme Court, again taken in the review application. And this view was accepted.
Yes.
So after dismissal of the SLP, my lord, if it is pending since long, not yet admitted, review is required an order 47 is required an admission. That is yet not been admitted yet. Another judgment you want to rely is that is not incorporated in the citation. Citation is, my lord, 2007 3 Calcutta High Court notes 178. Division bench presided over by Justice Bhattacharya. 178. Yes. On this proposition, review.
Paragraph 10.
Yes. The view is, my lord, if the order of a judgment or a declare of law, if it is judgment in rem, that also will not have effect. It has not been decided.
What did you say?
If it is not the judgment in rem, so it binds the parties till such time that is altered. So today, can it be said by the state otherwise than who has been decided against him?
Justice Bhaskar Bhatta, Niranjan, Piyush Kanti.
Oh, I am not aware of it. Paragraphs 10, 8.
10 আছে
Not binding on that.
এই যে এইটা
Paragraph 10.
Paragraph 10.
That is Chamunda Moped, my lord knows, relying on that judgment, this judgment was there. I will hand over a copy to my lord. Chatterjee,
Yes, yeah.
new I can give to Justice Chatterjee. Everything is known to my lord.
No. I heard about this. Yes. And Mr. Basu, senior advocate, appealing for the petitioner.
24 March, and you have said to us that no adjournment. And very clear in the order. That we wanted to make it clear in the earlier orders also, but for you, hello. At 2 p.m. নয়টা কল করে within 9.
Advocate Kakuli Somajpati is appearing in this matter. We have received the opposition in 17th February for filing the, we did not affirm the, please 2 days accommodation.
Malad,
12.
let me file Malad the affidavit in opposition.
Oh, yes, yes.
Because yes, they are for it to do.
If it may please your lordship. Lordship, I filed 2 applications for impleadment in this. In 13, can 2 and can 3, lordship.
Read petition.
No, appellant. Who is the appellant?
Sorry, Kishala.
Kishala.
Rishabh Ahmed Khan.
I bow my head down, my lord. I was just outside the court.
Yes.
My lord, this is my appeal, my lord. My lord, if my lord takes up the last order, my lord, my lord, if my lord takes up the last order, my lord.
This, Mr. Bandyopadhyay is against
My lord.
Service Commission.
Yes, lord.
Wait for an adjournment today, but we didn't keep because you were not there. Can we keep it on next Thursday?
My lord, no.
Any interim order you are seeking?
My lord, I am seeking interim order, my lord.
Let it be there tomorrow. Let us see how we feel.
I'm sorry.
Lordship, there are 2 applications for impleadment.
Okay, remind us on that.
I have not been served with the application.
I'll
Serve
serve
with
him,
them
my
in time. upon
Most
all.
deeply obliged.
My lord, since my one innocuous prayer, my lord, since my lord, my learned friend has come up with an application, my lord, for I believe it is for addition of party, my lord. And my lord, I am in opposition of this application, my lord. If my lord allows me, my lord,
You have prepared opposition.
my lord,
Even without, he says it hasn't received. So sorry.
my lord, from the case status, my lord, if my lord that this application is for addition of party, my lord, and this is an application for addition of party, my lord. What I pray before your lordship is, my lord, kindly gives us a liberty to prepare one opposition against this application, because we are opposing any addition of party into this matter.
So very good. When can you file? Tell us.
My lord, I can
Addition of
prepare it
party
today
app-
itself.
Huh?
Today itself. By tomorrow it will be ready. Because my lord, this matter is of highly contentious matter, my lord. Therefore,
So
my
very good. You addition of party you are opposing.
My-
But what is your stay application? Stay application he is not concerned.
is not-
Any urgency?
My-
What urgency is
My
there?
lord, the urgency is, my lord, the matter relates to the tainted candidate, my lord, who was marked as tainted by West Bengal Central School Service Commission. I say today that I am not a tainted candidate.
That Mr. Chatterjee was
My-
arguing.
that matter which was
Oh. Tainted, untainted. করবে না। It appear tomorrow, let us see how.
Meanwhile, my lord, I will prepare an opposition.
চলো দেখে দাও। আচ্ছা ঠিক আছে, 14টাও কাল থাকবে, তাই আছে।
আসুন আসুন